May it please your lordship. May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 6 of today's daily list, lordship. Lordship, my senior Miss R.D. Majumdar. She is the petitioner in person in this case, lordship. She has been deputed for mediation training program in Sikkim by MCPC Supreme Court, lordship.
The petitioner who appears in person is engaged in some training program. A request is made to adjourn the matter, re-notify. A request is made on her behalf to adjourn the matter, re-notify on that goes to November, 6th November
Deeply obliged, my lord. Much obliged.
for hearing.
May I please, your lordship? For item number 7, the engaged counsel Madras is very sick, so he proceeded for his hometown. So kindly.
Engaged counsel is
Engaged counsel Madras is very sick.
mother is sick.
So he. proceeded-
Respondent's counsel.
Item-
It is stated that
In this case, lordship, we have urgency, lordship, because lordship, government has also placed the records that the respondent is defaulter, lordship, and therefore they are
stated that
taking
the-
time, lordship.
personal difficulty
Lordship,
request is made.
Lordship,
We'll give a short adjournment. A request is made on behalf of Mr. Singha, appearing for the respondent to adjourn the matter for a short while, as his mother is unwell. Re-notify on 19th September as well.
Item number 10, lordship. Only today I have filed a color number, lordship. I'm for the.
For the respondent,
Yes, lord. Yes, my lord.
Mr. Sharma has filed wakalatnama on behalf of the respondent. The service is complete. His name shall henceforth be reflected in the call list. Re-notify after 2 weeks. He may file, Mr. Sharma may file affidavit on behalf of the respondent in the meantime. Affidavit/compliance report. It's a contempt case.
Not lordship, it was some delegate thing, lordship.
Okay, affidavit on behalf of the respondent, if so desired, in the meantime.
Okay, it was extension regarding extension of.
Whatever you file, whatever you want. You want to, you are desirous of arguing orally without an affidavit,
No, no,
do
no,
it then. Okay,
along with all the matters.
okay, along with the other connected matters.
Obliged, lordship.
Wait, please, lordship. I beg to mention item number 20 with the concern of others, lordship.
Item number,
20, lordship, 20.
yes,
Lordship, we need 1 week time, lordship, for adjournment for 1 week.
a fresh matter, gentlemen, you don't send a slip, then you want an adjournment.
Lordship,
Mr. Gogoi appearing for the appellants, for the appellant state of Assam, prays for short accommodation.
lordship.
Re-notify on 20th September as well.
Oblige, lordship.
May I proceed? I beg to mention for listing, my lord, three readable, my lord.
The order passed by the single bench, when?
Yes,
Date
my-
of the
yes,
impugned order?
Yes, my lord.
What is the date of the impugned order?
Lord, it impugned order. I cannot remember, my lord. It was filed on 9/8/23.
9/8/23. All right, get it listed Wednesday, Tuesday, Thursday, whenever possible.
Obliged.
Daily list for orders, item 8.
Now what remains in this matter now? Almost everything has been, madam.
I think, huh? They were supposed to, that online, this thing, lordship, portal, about the portal and all.
So he said that time was required. Mr. Mazumdar. Where is Mr. Mazumdar? Vasu. R. Mazumdar.
I'm appearing on his behalf, your lordship. He's coming, he's on his way, your lordship. Can we pass over the matter?
Pass over.
Deeply obliged, lordship.
Item number 9.
May I please your lordship?
Hmm.
Lordship, service is awaited in this matter, but in IA, your lordship, the service was completed, lordship.
No. Fresh service has to be effected in the appeal. That
Lordship,
was limited for the purpose of IA.
lordship,
Hmm. What is the office report?
lordship, AD has not been returned.
Notice sent to the respondent has not returned after service by registered AD post has not returned after service. The AD card has also not been received. Thus, let steps be again taken within 3 days for effecting service on the respondent. Whereafter, process be issued to him by ordinary process as well as notice be issued to him by ordinary process as well as by registered AD post. Rule is made returnable in 10 weeks.
Item number 14,
May it please your lordship, my lord, in this case, lordship, service of respondent number 1 and 6, lordship, awaited lordship. As part of
You are
this,
paying for all respondents,
Yes, your lordship, secondary.
1 and
education.
6 as well.
Yes, your lordship. Secondary education.
MS, your good name, madam?
P Das.
Pidas. No, number 1 is the red petitioner. You can't appear for him. So should we await or send fresh notices?
lordship.
We have awaited
Lost
already on
is-
16th August.
Lordship,
fresh,
perhaps he
uh,
lost his. interest.
Service has not been effected on the respondents numbers 1 and 6.
Please can my learned friend may appear, lordship,
uh,
because he is the principal of the.
MS
lordship.
Das appears for the respondent number associate to Mr. Mozumdar appears for the respondent number 6 as well. However, notice has not been served on the respondent number 1. Steps be again taken within 3 days, whereafter process be issued to such
Steps,
respondent.
Fresh steps. We can.
Rule is made returnable in 6 weeks.
Lordship, I pray, lordship, there is some subsequent development. May I file a additional affidavit in?
Can we restrain you from doing so?
Deeply obliged.
You don't need our permission whether to take it on record or not. That is a different thing.
item number 15,
56 days. Original file, main appeal file. Seniority. But issue notice of the interlocutory application to the respondents. Service be effected by service MS Das associate to Mr. Mazumdar puts in appearance on behalf of response numbers 2, 3 and 4. Thus steps be taken for respondent number 1 only. Rule is made returnable in 6 weeks.
Deeply obliged.
item number 16,
31 days. Caveat. Who is in caveat on behalf of respondent number 1? Check. Is there a caveat on respondent number 1? Caveator. FU Bharbuya. Issue notice. May MS Das associated to Mr. Mazumdar puts in appearance on behalf of the respondents numbers 1, 2, 3 and 4. The steps for service on the caveat has been entered on behalf of respondent number so and so, respondent number 1. Thus, steps for service on the remaining respondents within bracket respondents numbers 5 to 9, 5 to 8 be taken within 3 days, whereafter process be issued to such respondents.
item number 17,
What is the application?
My lord, this is a limitation application, my lord, delay of 13 days, my lord.
13.
1-3, my lord.
Who appears for the respondents?
Respondents,
Mr. Gupta, you appear for all?
1 and 2, my lord.
1 and 2.
My lord.
And 3, my lord, I think we have served one copy to the other side. And what I remember, my lord, there was a caveat. I don't know how it was skipped out when we go to
Is there a
the,
caveat for respondent number 3? Check.
then we served a copy to the other side, my lord.
Who appears?
Deepam Bora, Advocate Deepam Bora.
Madam, you are appearing for respondent number 3?
Sir.
All right.
Uh,
Issue notice. Mr. Gupta appears on behalf of the respondents numbers 1 and 2. MS so and so associate to Mr. B. Bora appears for the respondent number 3. The service is complete. Copies of the interlocutory application they have already been provided to interlocutory application seeking condonation of delay. Should we condone the delay? 13 days.
13 days can be.
This interlocutory application has been preferred by the appellant seeking condonation of delay of 13 days occasion in filing of the connected writ appeal. Having heard and the respondents have not filed any objection to the prayer for condonation. Having heard and considered the submissions advanced by the counsel for the parties, and after going through the grounds set out in the application, we find that the delay has been properly explained. Thus, the application is allowed and the delay is condoned. Registration number, the connected writ appeal, and list the same for admission after 1 week.
Deeply obliged.
Item number 18.
May I please, your lordship? My lord, sir, in this application, my lord, there is a delay of 6 days of in filing this instant.
Delay?
my lord.
You are appearing for all, Mr.
No, I'm
Monta?
for one only, my lord, 5.
Number 1.
One.
There are other respondents. Union of India, State of Assam,
Some
Director SCRT,
and Dibrugarh University.
Restart Dibrugarh. All are represented. And Union of India,
JC Kamal.
Deputy SGI. We find Mr. Chaudhary to be missing in action for since last few days. Where is he? All right, mark the attendance and then IA seeking condonation delay of
6 days.
6 days. Delay condone, application allowed. उससे ऊपर वाला देख लीजिएगा।
Item number 19.
Maybe.
Hmm.
But the petitioner applied for the compassionate appointment.
Yes, madam.
Appointment of
It's just a
compassionate.
case of the wrong schooling living certificate being filed.
Lordship.
He has a qualification otherwise also. If you consider the application, you will get the verification done. So if he had the qualification and due to ignorance, he is applying for grade 4.
My lord.
So if by sheer ignorance, he could not file the proper school certificate. Why should he be penalized? Then of course, we'll make it subject to the condition that there is a vacancy for that particular year still available.
My lordship. Lordship, may kindly observe that much, my lord.
We'll make that observation.
Because it is year of 2015. His
Yes,
father died.
yes. If there is any vacancy of that year, then he may be considered.
Lordship,
And of course, after due verification of the 8th standard certificate.
my lord. Lordship.
I'll dictate. Okay. Writ appeal allowed. Small.
Obliged.
Okay.
Deeply obliged, my lord.
Item number 21.
But in this case, as per last order, my learned friend asked that the matter is placed before the
The
expert.
committee is looking for
Now-
that, my lord, we are yet to receive a report. Perhaps.
Mr. Mazumdar submits that the report of the committee has still not been received. He prays for academic committee.
Committee.
He prays for and is granted 4 weeks time to place the report on record. Further opportunity 4 weeks.
A date, my lord, after 4 weeks, my lord, kindly please.
Now it goes to November then. Re-notify on 8th November.
Obliged, Lordship.
8 November, huh? Order to put the.
Item number 22.
May I please, Lord. Now, this central excise appeal has been preferred, my lord, challenging the order passed by the, my lord, tribunal, my lord, by directing the appellant to, my lord, for pre-deposit.
Pre-deposit.
Lordship, in
It's a
fact, in
mandate
the-
of law.
my lord, in the present case, Lordship, there was no demand at all from the, my lord, adjudicating authority or by the first appellate authority, my lord.
So what was the appeal against?
My lord, appeal against the, my lord, setting aside order passed by the, my lord, the first appellate authority, my lord.
Setting aside.
Lordship, my lord, what
Let
was
us read
happened?
the order.
My lord. My
Let's
lord, your
read the
lordship
order.
will find that page, lordship, 56, lordship.
Hmm.
My lord, what was happened, lordship? Initially, my lord, central excise, my lord, sunset credit was allowed to the, my lord, appellant, my lord. My lord, so cause notice was issued, my lord. It was supposed to be, my lord, recovered, saying, based on that, my lord, that we have utilized the sunset credit based on some wrong documents, my lord.
Hmm.
We have submitted our reply, my lord, and being satisfied, my lord, the SOCOS notice which was issued, that has been withdrawn, my lord, the proceeding was dropped.
Okay.
Against dropping of the proceeding, my lord, department has preferred an appeal before the appellate authority, my lord, and that has been allowed by saying that the dropping of the proceeding was not correct, my lord.
So then the demand stands revived.
Lord, there was no demand, my lord, it was only the SOCOS notice, my lord. In fact,
Recovery, all right, it was not a recovery, it was only a show cause.
lordship, lordship.
Scale. What do you say?
Lordship, against suppose notice,
So how it is a demand?
Lordship, since the appeal has been allowed, so it presumed that,
There was no demand originally. It was only
No.
a proposal, a query. Why the Senvet credit extended to you should not be cancelled, recited.
no, Lordship, Lordship, the Soco's notice and demand.
So how much is the amount, valuation of the appeal?
Lordship may please to see,
The entire amount of show cause notice?
no, Lordship.
Why?
67, page
Yes,
67.
yes.
The part of appeal filed by the appellant, column 14, Lordship.
So that must be the amount of the Senvet credit availed. But that is not, there is no order whereby that amount has to be,
Recovered.
has been demanded from him. There is no order of recovery as yet. They are still contesting your show cause notice, basically.
No, Lordship, that was dropped.
Yes, so that was dropped. There is no demand.
Then thereafter, department preferred the appeal. And
Therein there is a remand. There is a remand against the order of dropping has been set aside.
Lordship, learned CSET also in paragraph. Lordship.
Mr. KL, can you rule out the situation wherein the show cause notice, the proceeding, supposing they are taken forward,
That is correct.
and only a partial recovery is directed? Then why the litigant should be forced to deposit the percentage of the entire amount of the Senvet credit, which still there is no determination, as a matter of fact, that the recovery has to be made.
In fact, it is not.
That is a fact.
Yes, Page
Then-
page 19, Lordship Tribunal observed that since the appeal was allowed, so it is presumed that they have to pay this amount.
How can there be a presumption of that your authority will, on demand, as a matter of fact, raise the entire demand against them or direct the entire recovery? It's possible that partial recovery may be directed. Part of their documents may still be relied upon. You can't rule out the possibility. But, and yes, the demand was dropped. Thereafter, of course, they have a right to challenge. You can't even take a objection that show cause notice is under challenge.
Or Lordship, the appellate tribunal, appellate authority also not observed that demand is confirmed. It is also not there.
So, my lord, we are only aggrieved by the, my lord, or directing for pre-deposits, my lord.
Also may dispose of.
We'll say that pre-deposit in the peculiar facts of this case will not be insisted upon and the appeal will be considered on merits.
This
आप दिखाएंगे? There was a show cause. It was dropped. What? Recalling of the Senvet. Recovery. Then the department went to the appeal. The appellate authority had order stopping the then Pre-adjudication is being made. It's pre-adjudication stage. All right, appeal allowed. With the consent of the. Start it like this. With the consent of the- until there is no further admission. With the consent of the learned counsel for the parties. The appeal has been heard. Finally, and it being declared to the decision. Like this you start. At the stage of admission. Yes. Good news. Basically, brown people, there is no demand. There is no demand. Okay, they influence for it. Yes.
Item number 23.
May I please?
Old pensions,
Yes, Madam, similar matters have already been admitted. Lordship may kindly be pleased to tag this.
admit
matter.
issue notice, Mr. So appears on behalf of the respondents.
That I appear for the finance department. Here it
Finance
is my lord respondent number 2,
Who would be appearing for the elementary education?
elementary, my colleague is there.
Elementary education, mark the attendance. Connect and list with so and so.
My lord, it is writ appeal number 156 of 23.
25 is also the same.
Yes, my lord.
Yes,
Admit. Connect.
I'm so obliged.
obliged.
Item number 24.
Same. Not 20. No, 24 is different. 24 is different. Yes, 24.
May I please, your lordship? This is a matter of compensatory appointment, lordship. Lordship, question is
15
that-
years. After 15 years. Your mother had a right to
question is,
agitate the cause.
mother has also applied, lordship. with-
Applied, it was not considered. She should have come to the court. That doesn't give the right to the daughter to approach after 20 years, 15 years, whatever the case.
Lordship,
And then what is wrong in the order? You are underage, it's a fact. Why were they supposed to defer it?
lordship, he has no male member in this family. Male member is not.
We are not bothered about that.
This,
She was not 18 years. She could not have applied for government job. No dispute.
no, lordship, there is Supreme Court judgment is also there.
Let us see the judgment.
Lordship, question is, first I lordship come to you. Under first page 15, lordship, I challenge this order, lordship. No, last paragraph, lordship.
Yes,
where
we have read that order, gentlemen.
15th page, lordship.
Hmm.
It is the DLC order, lordship. Whereas after scrutiny of the application submitted, it was observed that the applicant was underage at the time of submission of application.
Hmm.
Her age is at the time of submission of application is 17 years, 11 months, 6 days. lordship.
Hmm.
Only 24 days.
Doesn't matter, gentlemen, why they are supposed to consider the application of a person who is not eligible,
Lordship,
who doesn't have the age
lordship,
to
question
apply
is
for a
that,
government
lordship,
job.
according to Supreme Court judgment NC Santosh, lordship,
Yes.
in the time of consideration, when he is over 18 years, he can consider. That's why
Let's
I
see the-
also,
Let's see. Where is the judgment? Let's see. Come, give it. And what do you have to say on delay?
page, para 19, lordship, in this,
Hmm.
para 19, lordship. Applying the law.
There was a provision which allowed the minor to apply within 1 year from the date of attaining majority.
It is correct.
Herein, is there same provision in the rules, in the guidelines?
I also follow, lordship, because my mother also applied.
So your mother applied, she never agitated the cause. The the fundamental concept of compassionate appointment is penury and to tide over distress. So your mother applied, she forgot about it. She survived for all these, the family survived for all these 16, 18 years.
Lordship,
So then where's the question of compassionate appointment?
question is, Lordship, that his mother applied Lordship in that time.
Maybe,
According to Lordship, Supreme Court judgment, I also annexed Lordship here.
yes.
Page-
So this NC Santosh doesn't apply to you. There in the rules permitted the minor to apply within 1 year of attaining majority. There is no such provision here.
Page 21, Lordship, my Sayyid Kaddam Hussain, Lordship.
Hmm?
Versus State of Bihar, Lordship.
Yeah, read.
Page 21, para 5, Lordship, in this judgment. Supreme Court is also consider his mother.
In that case,
Mother is applied,
they
But
proceeded
she was
on the assumption that application was rejected.
rejected.
There is no rejection here. That was a period of 5 years.
Lordship,
Here we are looking at 17 years. It makes a huge difference.
They said yet to become, yet you can, in next DLC, but it is not considered, Lordship.
Have you
If
placed,
give me-
have you placed
whether
any,
they reject
Ms.
me,
Council, will you listen to us, please?
Lordship,
Have you placed anything on record to show what happened to the mother's application?
Lordship, it is my wrong, I faked them very. I faked the department, Lordship. They tell me after next.
Let us read your
next
pleadings.
DLC, Next DLC.
Read the writ petition.
Lordship, Lordship.
What have you said about that?
Lordship. My question is that according to their.
Can you
advice,
please
I
read
filed this.
read the pleadings? When did your mother apply?
Lordship, para
6.
fact of the case, first paragraph also I am writing, Lordship.
Read, let's see.
Lordship. Page 2, Lordship, in my.
Your writ petition, gentlemen.
It not
Writ petition, please.
read appeal, Lordship.
No, writ petition.
In this petition, I have challenged only the
So
time.
there is no pleading in the writ petition that your mother applied. It was not considered. Why should we consider this
I am
ground
not,
in the appeal? A ground which was never agitated before the single bench. They never got the opportunity to.
I submit. Lordship.
Sorry, sir. No,
I already submit, Lordship.
absolutely no, sir. Absolutely no. Thank you.
Lordship, kindly, Lordship, he is a very poor girl, Lordship. Only single girl.
All sympathies, sir. There are other measures of getting employment, not compassionate appointment. Thank you. Rejected. Yes, next.
Item number 26 to 28.
This is the appeal by the revenue. Lordship, the main question here is that the CD seized during the search and seizure, whether that constitute incriminating materials. Otherwise, only in Supreme Court recently in Abhisar, in that case, it is held that if there is no incriminating materials, there will be no reopening of the assessment. But here, Lordship, I want to place that the materials seized, where they can be termed as a incriminating material.
Increment. So that is a question of fact.
Lordship,
That is purely a question of fact. How can it be it can't even be a mixed question of fact and law.
Lordship, because that was the basis for reopening. Lordship.
That was a,
Basis for reopening of the assessment. In page
understand,
16 paragraph 7. Lordship.
when you come in appeal, you have to satisfy the court that there are substantial questions of
Yes,
law.
Lordship, that-
So whether the CD constitutes incriminating material or not, that can never be considered to be a question of law.
Lordship, this is the only, otherwise the Supreme Court has already held. And Lordship, in another case, Lordship, has-
We already decided that.
the judgment has not come.
So all right, come to the judge. We have heard it.
Yes, Lordship.
We have pronounced it. Huh? You already pronounced the judgment. Yes. Dr. Saraf, we have pronounced that judgment. No?
We have not got the copy, but
Yes.
the tribunal, my lord, specifically dealt with that what is the incriminating material. meaning of incriminating material.
Page number?
I mean, I'm giving you. And thereafter came to conclusion. The incriminating material you have to find. Meaning of incriminating material. at page
9.14,
9.9 at page 539.
539. Even CIT appeals
My lord,
decided the same.
nine point nine, my lord.
Internal page.
The previous
Yes.
discussion of what is the meaning of incriminating material, and thereafter came to conclusion that these documents which were found is not incriminating material. Because that were already on record.
Almost same facts as what we decided in that case. Same facts.
My lord, one more question was that section 58, that addition has been made, that has also been dealt with, a question you framed. My lord, the court, tribunal has come to conclusion, my lord, the genuineness, competency, and my lord, the credibility had been proved. Once it is proved, my lord, this becomes a question of fact. So the other questions which have been made, my lord, that section 68 addition should have not have been deleted.
Yes.
That also is self-answered, my lord, which is at page 554.
Dr. Saraf,
My lord,
we'll defer it to Wednesday. Please give a brief response to the questions of law, proposed questions.
my lord, I will just give the paragraph numbers also and find.
And yes, please do that. Wednesday. In the meantime, please have a look at the judgment. As jointly paid, list on, re-notify on 13th.
Item number 29.
The last order says the last opportunity for my affidavit, but I would require 1 week's time. I had to send back the parawise comments, whether they did not refer to one of these sections.
Mr. Mazumdar submits that the parawise comments which he received for preparing the affidavit were containing insufficient material and thus some more time is needed to file the affidavit in opposition. In the interest of justice, one more opportunity is granted to Mr. Mazumdar to file the affidavit in opposition. What is the writ petition about?
My lord, they have challenged the provisions of the rules where persons who were brought in from LP schools on amalgamation are not given the opportunity of becoming principals or vice principals.
Okay, re-notify on October 17th October.
Obligation.
Item number 30.
May it please, Your Lord.
Yes, please.
Lordship, in this matter, the state respondents were directed to bring on record the inquiry reports of the 4 institutions.
It has not yet been filed.
My lord, an affidavit has been filed. If your lordship kindly peruses the affidavit, my lord, it starts at page number 75.
Yes,
If I may take your lordship to page 77.
yes.
My lord, a consolidated report of the tests carried out by different agencies regarding presence of formalin is as follows. Now, my lord, before I take your lordship to this particular table, if I may take your lordships to page number 87 of the affidavit filed by the private respondents. They have brought on record the food safety and
FSSAI standards.
Development regulations of 2020.
Yes.
So, my lord, if I may take your lordship to clause number 2.6.2 at page 87.
Yes.
The amount of naturally occurring formaldehyde shall not exceed the limit prescribed in the column number 3 for different species of fish as mentioned in the table given below. So, my lord, we are concerned with freshwater fishes, which is at page 88.
88.
88, my lord.
Now, where is the table?
My lord, the table starts right below.
88, yes.
So my lord.
4.0,
3, yes, my lord, it should be 4
Within-
milligrams per kg.
less than 4.0 per kg,
Yes, 4 milligrams per kg.
4 milligrams per kg.
Yes, my lord.
How do you say that it is 4 milligrams per
My lord,
kg?
it is at page 87.
87 at top.
Page 87, column 3. The
Yes,
heading.
yes, yes.
It says maximum limit milligrams per kg.
Yes.
It should be 4 milligrams per kg.
Hmm.
Now, my lord, I take your lordship back to page number 77.
Hmm.
Page 77, my lord, serial number 2
Yes.
of the table.
Hmm.
The institute which has carried out the test is College of Fisheries, Assam.
Assam Raha
My lord, it was carried out in May 2023,
is 13.89 mg.
13.89 mg per kg.
So that was only
32.3.
32.3.
32.3.
That's really excessive.
Yes, my lord. Now again, my lord, if your lordships, if we take in percentage, my lord, it comes to 0.00134% to 0.00325%.
Hmm.
Now, my lord, if we count in percentage wise, if your lordship kindly takes up serial number 3 of the same table,
Hmm.
my lord, the percentage is much more than what is at serial number 2.
Hmm.
Now, this test was carried out by Guwahati University. The percentage is 0.
Who's appearing for fisheries? Madam Bhattacharya was there earlier.
My lord, she was there, my lord, today and take up, my lord, because file is not with me, my lord.
So this is quite serious.
And my lord,
The reports
the-
show alarming
the-
levels of formaldehyde.
my lord, Nagaon College is even more serious if your lordship sees at serial number 4.
Arsenic,
Cadmium and arsenic both.
they are all heavy metals.
And again, Dibrugarh University shows even higher amount than Guwahati University, my lord.
No, it doesn't. You see the number of decimals.
Oh, sorry, my
Triple
lord.
zero
Yes,
six
my
two
lord,
nine.
000. My lord, maximum is Guwahati University
Yes.
and cadmium and arsenic by
They are
Nagaon College.
very dangerous. They are all heavy metals.
My lord, may I pray 2 days time to my lord?
13, Reno,
My
Mr.
lord, if
Bhattacharya,
it could be on 14, 13.
MSM Bhattacharya, that senior government advocate is not available today. Re-notify on 14th.
Only a small prayer, Lordship, on 8/8/2023, Lordship has passed an order that the government will give us the copy. They have filed their
Yeah,
affidavit. We do not. have the
re-notify
copy. Lordship has
on
Passed an order.
19th September. In the meantime, the reports referred to in the order dated so and so shall be provided. Copies of the reports referred to in the order dated so and so shall be provided to and counsel representing the petitioner as well as the counsel representing the
My
respondent
lord, I have
intervener.
already received the
Already received.
affidavit.
I have not,
Intervener.
but I am appearing for the Nagaon College. Lord.
Respondent number 4, my lord.
Respondent number
the
4.
senior.
19th September.
And my lord, the reports have not been brought on record. It's only.
That's
the
what we are
table.
That's
saying.
the whole problem.
You have been given a copy.
No, my lord, not
No,
the
So the
reports.
copy, the reports
The reports have not
referred to in
been.
the
brought.
order shall be placed on record after providing copies thereof to land council representing the respective parties.
Lordship, can it be on 22nd, Lordship? On 19th, I am not.
22nd, all right.
Oblige, my lord.
Item number 31.
Maybe your lordship.
Hmm.
My lord, they have filed the affidavit in opposition, we have filed our rejoinder.
What is the matter about?
Ma'am, matter is about your lordship challenging the virus of section 43D5 of the unlawful activities prevention.
Hmm.
My lord,
So we'll admit it, hear it at length. This
Hello,
can't be
there
done at this stage of admission.
of course, my lord.
Admit. Pleadings are already complete. List for hearing in November.
My lord, there is one issue which I would like your lordship, because this petitioners, your lordship, their handicap in a sense is that though in the trial, the
Hmm.
witnesses are, the evidence which was there at the prior to the framing of charges are getting
They
died.
are not at all concerned with the merits of the matter. It's a question of validity. We will examine.
A date, my lord?
November date दे दीजिएगा 20th 21st November.
Oblige. Oblige.
Passover meter, item number 8.
So all the testing and everything regarding that site has been done, and we hope it will be operation in a week or two. So if it is taken up on the first week of October, possibly we'll have.
Online process. The portal, for,
Registration of the schools.
setting out details of the RT admissions will be formally will become formally operational within next 2 weeks. 2 weeks?
They say end of September.
The latest factual report, detailed factual report will be placed on record by next date, re-notify on 10th October.
Published.
Deep blue. Yeah.
Supplementary list, item number 32.
Lordship.
Hmm.
So this appeal has been filed because in the writ petition, actually, we respondent was never ever issued any summons. And despite the single judge giving directions also, it has never been served. On the last occasion, yes.
Service of what?
Summons, we did not knew actually. The
Summons of what proceeding?
writ petition.
You didn't get this summons of writ petition?
No, we didn't.
Right, then we'll call the original file, see the service report,
Yes, ma'am.
get the original writ file.
No, notice was not issued to them at. On the
It was a
first day,
limine order.
Lordship, notice was issued to them at the initially at the motion stage. Subsequently, my lords, the court felt that it is not necessary to issue them notice. Because when proceeding under section 14 before the deputy commissioner, they are not a necessary party, they do not have any right of hearing. So in that view of the matter, my lord.
But you came in a writ, gentleman. Maybe,
Yes.
maybe in proceedings before the deputy commissioner, they were not required to be heard. But when you are coming out, you have pleaded them as a party.
Yes,
And any adverse order is being passed by the writ court,
Yes, ma'am.
excising 2 to 6, why they are not required to be heard?
no, that may be. My lords, the fact remains that this matter was to enforce the ministerial duty upon the deputy commissioner to
We
carry out the
understand,
duty under section.
we understand.
That is the limited right.
That is right. That is right.
And as far as restoration of possession is concerned, his rights are still open before the DRT. my lord. He can always go
Yes.
and my lords, he can agitate his rights there. Because my lord, the fact of the matter is, lordship will, for a moment, lordship will come to my lords, page 91, my lords, of the paper booklet.
Hmm.
Page 91 is the sale certificate.
All right.
This
Okay.
sale certificate, my lord, the public auction was carried out.
Mm.
A person has purchased this property. We do not know as of date, but perhaps he has
Already
made
taken
the-
possession.
Lordship?
Already taken possession.
No, not position. Position could not be taken because position first we had to take through the office of the deputy commissioner.
Okay.
Now he is pressing upon us for for the action of position. As of now, my lords, if any order is passed, then he is required to be implemented as a party also. Because as of date, I am in the nature of a receiver. Or
Yes, you are right, you are right.
he is required to be.
Now, why you are required to be heard? Tell us.
Yes, ma'am.
What is your status?
Because actually in the read edition, we have submitted in the additional affidavit, which in the page number, if my lordship comes to around page number 98 actually. Additional affidavit. This was the first instance when the read petition was there. In point number 5 actually, issue notice on the respondent number 5, 6 and 7. Returnable in 4 weeks time. And point number 6, the petitioner shall take steps within 2 days for service of notice on the respondent number 5, 6 and 7. But
Mr. Ganguly, once notice was issued, where was the occasion for the writ court to proceed? Then record a finding. That amounts to recalling of the earlier order.
That amount, and in fact, my lord, the proceeding was thereafter listed before another bench also, my lord, and that bench heard it for 2 days, my lord, then again before the Lord's
matter once notice is issued.
No, this, my lord, I would argue this is a case of a empty formality, my lord, because
Maybe,
notice,
maybe. Then you need not have implemented them as a party.
we did, my lord, because
Then
what
you
happened is
did,
that
then they were required to be heard a writ court. You
Yes.
see, the same concept, consider in a criminal case. For taking cognizance, the proposed accused is not required to be heard.
Lordship.
But if that order, supposing there is an order whereby the court doesn't take cognizance
Lordship.
and dismisses the complaint, if that order is to be challenged in the revisional court, the proposed accused would have to be heard because the right has accrued.
Because what has happened in this case is that since they have no right of hearing, as the Supreme Court has said repeatedly under section 14, the writ court, in my humble submission, felt that it is not necessary because it is a ministerial duty cast upon the deputy commissioner. They have no right of hearing before him, so they were not required to be heard.
Now, already, what do you say to this argument? Okay,
Lordship, if I-
assuming you were not heard,
Proceed.
notice was issued and you were not heard.
because notice was not
I
given. to
forget
me.
it. What is your right to be heard? First, let us know. So if there is no right to be heard in the original proceedings,
Lordship,
was there any prayer against you in the writ
Lordship,
petition?
when the physical possession was taken in the month of March, actually, then the RO resealed it, stating that the mortgage property belonged to a dead person, it cannot be sealed. So we again got the keys actually. It has not been done as per law. And if I proceed in this writ petition in page number 101 actually, please in this one, the Rajama Court in page number 1, the mention is that the office noted 17/7/2023 reveals that the petitioner have not.
That they don't dispute. Ms. Ganguly, it will be fair that once notice has been issued, let them be heard.
Lordship, if I go,
And
If
Lordship
I-
will also consider the impact of section 30.
You understand, but what he says is that it was proceedings were taken against a dead man. Then he has a right to protest.
Milord, if that be so, Milord, he went before the DRT, that order is on record, he has filed that order. Let him show whether it was a dead man or whether these petitioners went on record, Milord. Let him show it. It is there.
What we suggest
Lordship.
is appeal before DRT is pending.
No, nothing, Milord.
no.
They filed the essay
No.
before the DRT dismissed. They went to DRT asked them to deposit 35%.
They have
did
not deposited.
That has also been dismissed.
So there is nothing, no
There
pending
is
proceeding
nothing,
now.
Milord, and
that is not the
There is
question
nothing.
over here.
It is indeed a question, sir.
No,
That is definitely a
Lordship,
question.
I could like
Yes.
to say this, actually, this is not this one. See, the Lordship, the permission was obtained by them. The DC again, after the DRT recalled, the DC again went in the month of March. DC also recalled it. It was done physical poison, then DC also recalled it, stating it cannot be done. 2 times they have done, and now they have.
Where is
not
that
implemented-
proceeding? Where is that proceeding where the DC recalled it? Let us see. Have you placed it on record?
Lordship, because we had been given the keys, actually in the writ petition, in the order was passed 2 times actually. First on the March.
Read the order.
Lordship, I could like to state in the petition where they have mentioned, Lordship, can you come to page number 38 actually?
Lordship will kindly come to Milord. Page 85 onwards. These are the findings of the DRT, Milords, because thereafter they went to DRT, they took the very same ground.
Come to
before the-
para 8. In view of these pleadings,
Para
why
eight-
don't they? Yes, why
That
don't they
on
have a
eight-
right to be heard?
That on
Hold on.
18.
Lordship is relying on.
On your writ petition para 8. page
Right,
38.
that on 18/3/2023, the respondent number 3 executive magistrate along with the police personnel and the bank official went to the secret asset to take physical possession, but the private respondent somehow managed the district
So there
magistrate.
is not, the things are not so simple as they seem.
No, Milord. On 18/3, Milord, these orders were passed subsequent to an earlier order of physical position, which is also on record, passed by the deputy commissioner. Milord, don't want to say anything on record, Milord. Whatever they did, Milord, on that day, the deputy commissioner, without any written order, postponed the thing. We were constrained to come before this honorable court that look here, this is a proper.
Ganguly, all said and done. Once you have implemented them, notice has been issued. Then what is the hot haste? Why couldn't you get them served? We'll simply say remand the matter to the writ court. They are already here. Service is complete.
In that
Get it
case,
heard in,
no issue, my lord, but in that case, my lord, no orders may be passed without implementing first the, because that person is now no longer the auction
impleading
purchaser.
who?
The purchaser, my
In the writ appeal.
lordship.
Writ appeal,
No,
we are
not the
simply
writ
remand.
appeal, my lord.
In
In
writ
the-
petition is your writ petition. You will have to implead.
That liberty may be given. my lord.
Yes, we'll do that.
Lordship.
All right.
Because any order passed now will be to his detriment, not to ours. my lord.
Yes. When was that sale made?
My lord, sale was made. The sale certificate was issued, my lord, on 12th of December, page 91.
So then your writ petition was decided on what date?
My writ petition was decided, my lord, in the month of March, in the month of August.
August 23.
Yes.
Then you are required to implead.
No, my lord, the auction purchaser didn't want to get him in. We will implement, there is no difficulty in that. No, he doesn't
Your
want to
writ
come.
petition came, now you are saying implead.
No, I'm not saying
Give us
that,
permission. Your writ petition was pending.
Lordship,
Your writ petition was filed after the sale certificate.
after the sale
So
certificate.
then why didn't you
Because it is
implead?
our duty, my lord, it is our
Who
statutory.
prevented
duty to hand
you?
over the-
Who prevented you from impleading him?
No, we
Now
did,
you
my
are
lord.
seeking our
I'm only
permission.
pointing out that any order passed now will be to his detriment, not to our detriment, because, my lord, as of
Now
today,
let
my
me
instruction
permit you.
is,
We'll permit you to complete
Lordship.
writ appeal allowed. Permission granted to the appellant to respondent bank to implead the sale purchaser so and so as a party respondent to the writ petition. The appellants and the respondents, writ petitioners council shall appear before the single bench on 9th October post restoration of the writ petition to its original number
Lordship has said appear before the, my lord.
on single bench.
Single.
9th October.
Lordship, the property is locked. Can we approach the,
Whatever you want to do, you do.
okay,
Nothing beyond that.
Okay.
Impound order is set.
how like,
We are not interfering in their job. They may still convince the deputy commissioner. For all we know, they can very well.
Work is over, my lord. His work is over.
how like,
Item number 23.
Mr. Kurban? Mr. Shan?
Yes.
My lord, the writ petition was filed by the government when when rejected my claim for extension. But in the order it said that immediately the authority should go for
Tender,
tender process,
fresh tender.
fresh tender. And in the meantime, I may continue because I am still to deposit 10 lakh rupees. At that moment of time, the X came and approached this honorable court, challenging that government order. Ultimately, this writ court, my lord, said beyond 14(9), I cannot continue, and if necessary, the department will do the fishing. So I am against that order, my lord. What I'm saying now, the instruction was sought as to what is the
What has happened in the fresh tender process?
First tender has already been issued on the 1st of September.
Okay.
And
What is the period of-
reassessment has been done. And after doing the reassessment, my lord, NIT has already been issued.
NIT has been issued.
My lord.
Well, chapter close then.
only thing that, my lord, I understand. Now it's very limited. Only thing, my lord, what the authorities have said, that is page 32. My lord, second column.
According to him, the act is not only to recognize, but also to regulate. That is his first submission. I have no two opinion on that. It is to regulate the private sector schools functioning in the state of Assam.
Yes.
Basically, he has argued many things, but I would like to respond to his argument on section 10 of the act. Section 10 of the act, Lordship will find the requirements. So requirements for establishment and administrative recognition of non-government educational institutions. And he has highlighted that an institution will not be recognized unless it fulfills the following requirements. He pointed out one point. One, the institution shall own and possess a minimum area of land with clear title of the institution over it as specified as under.
Yes.
So for LP school, middle school, and the other high schools, Lordship, there are different specifications regarding the area, regarding the location of the land, all these things. And this honorable court was also pleased to ask me this question, why there is a requirement of owning and possessing? Why it is not lease or rent? First is that this objective of this act is very clear. We want to, if Lordship is pleased to come to page 573 for a moment.
Yes.
The unplanned and statement of object and reason. The unplanned and mushroom growth of non-government educational institution at primary, secondary, and higher levels of in the urban and semi-urban areas of the state has necessitated to make this law to regulate the establishment and management of all non-government institutions. So we want to check that there is no rampant growth of this kind of schools. The schools which my learned friends are representing, none of the schools have this kind of issues that they do not own a land. If there's a solitary case, Lordship, the case
They
would
are
be happy to-
existing schools, Ms. Saikia, they are existing.
They are
schools.
existing.
Otherwise also.
And
Now,
they-
now, let us take an example.
Yes,
There is an existing school which is running in a rented premises. What happens?
yes, they can run. This is already there in the act,
Okay.
section 10.
Yes. Read.
Section 10, Lordship will come to next page,
Mhm,
provided that
mhm,
non-government education institution already granted prior permission and administrative recognition with land requirements before coming into force of this act
mhm,
shall be allowed to run. So we allowed them.
Mm.
Which is, in case of new establishment, we are putting it.
mhm,
And there was a deliberation on this.
Mm.
So initially the act, the original act allowed lease as well as rent also.
mhm.
This is an amended provision of 2018. If Lordship is pleased to look at 10, down below, substituted clause 1 in section 10 by the Assam Act of 2018, published in the Assam Gazette dated 28 June 2018.
Mhm.
So the original act did not have this specification of owning and possessing.
Mhm.
Any plot of land which is on rent or having the possession of the school, that is allowed.
Mhm.
This is a subsequent development because there is a recommendation of a committee constituted under, I'll place a photocopy of this also.
Mhm.
The minutes of the meeting held on 3/11/2017
Mhm.
in the conference hall of Vice Chancellors of Krishnakanta Handik State Open University for Regulation of Fees of Non-Government Educational Institutions. There were 7 members with the VC of KK Handik, then BL Sharma, Director of Higher Education, Jidung, Director of Secondary Education, Director of Elementary Education, then Director of Elementary Education, the Assam Engineering Services, then Oporupa Chaudhary, Deputy Secretary, Assam Higher Secondary Education Council, and Anton Das, Under Secretary, Secondary Education Department. So here in clause B, I'll read out. I'll give a photocopy.
Yeah. Yes.
The Assam Non-Government Educational Institution Regulation and Management Amendment Bill 2017. The Assam Non-Government Educational Institution Regulation 2017 was thoroughly examined by the committee. The committee observed that in section 4 of the bill inserted for amendment in section 10 of the Principal Act, the land area should be specifically mentioned in the act instead of mentioning that the land area should be at par with other government provincial schools. Accordingly, the committee suggested that the following minimum requirements of land for establishment of different categories of non-government educational institutions in the state of Assam. For LP schools in rural areas, 2 bighas, municipal areas, 1 bigha, Guwahati Municipal Corporation, 1 bigha, and different categories of school and different quantum of land. And finally, the committee also suggested to restrict establishment of private schools only on the own land in the clear title of the school instead of lease as proposed by the department. So department wanted to have it.
Mhm.
This committee said that don't do that, to restrict the establishment of uncontrolled number of schools, you have to put this condition. So this is our stand. Now I leave it to this honorable court.
But we understand that. That is the purpose is that there should not be an area of uncertainty.
Lord,
Basically rental, supposing the owner says, now you evict the premises. What happens to the students? If they don't have any other
exactly.
place to
That
settle?
is one thing.
What,
Yes.
there's a technical issue we want to ask. what is the mode of, supposing it's a municipal area
Yes,
and the person who is desirous of setting up a school
yes.
wants to get a land from the municipal body. What is the deed which is executed? It is a lease deed, we suppose.
For that, the government will have to take a decision on that because
It is a
section,
lease. It is a lease. Municipal corporation will always issue a lease, maybe 100 years lease,
yes, Lordship.
but it will not be an owned property.
It will not
It is
be,
a lease property.
it's a lease property.
Then how do you operate a school then?
For that, that will not be a private school. That will be a government school.
No, supposing a person, say there is an auction by a municipality. Okay,
Yes,
municipal bodies auction their lands.
Lordship.
What is the nature of the document
But
execution?
here that is not in practice till date. That situation
see
has not
just-
come.
That is a situation which may arise.
This may arise. When it will arise, we'll definitely have to take a call. But Article 300 of the Constitution of India very clearly says, when the government or its agencies wants to part with any plot of land, either for permanently or on lease, then the government will have to take a call. Municipal board on lease owns cannot do anything. There's a protection
Municipal,
under the
there
Constitution.
there are provisions in the municipal act. It's there across the country, wherein the municipalities, whichever lands they are having, they've been given the procedure to sell, auction or lease out the properties.
Lordship,
But then the document which is executed in Rajasthan, it is always 100 years lease.
Lordship. Here it is 99.
99, that's
Not for
that's the-
schools, but for various other purposes.
for any purpose, commercial,
Lordship.
say it's commercial. So it will always be on a lease.
So that will be a different situation because that will be on a PPP mode, public-private investment, Lordship. That is a PPP mode.
Hmm.
Now here, the education department has a specific code now.
Okay.
So we do not want that. Why? Because we have to read it with the provincial legislation. Lordship knows in Assam, huge number of private schools were provincialized from
Yes.
1995 onwards. 2011, that act has been set aside by this
Mhm.
honorable court.
Mhm.
People having three schools in the same campus. All these things has happened. That is a history.
That is right. That's right.
So now 2017 Provincial Act, which is under challenge again.
Hmm.
In fact, there is no bounden duty on us to provincial, but in spite of that being a welfare state, the
That's right.
state has taken this action.
Hmm.
So we want that this committee suggested, there is another aspect, Lordship. Why this particular committee? Because this government wanted that it should remain as a rented property or leased property.
Hmm.
This committee suggested, and this committee is under this Regulation of Fees Act.
Okay.
They may divert this fund. Suppose 100 rupees is collected for as fuels and maybe 70 rupees is shown as rent. So the of the school authority, Lordship, they will reduce the fees for salaries for the teachers and they will invest less money for the development of education, for the libraries or for the laboratories, etc. So this particular committee suggested and the government has accepted. Although the department wanted that it should remain like earlier.
Like earlier.
So I'll place a copy.
Okay, please. Go.
And the existing schools, they are not hampered by this provision of amendment of
Okay,
2018.
Hmm.
In
Hmm.
provincial acts of 2017, as page 650.
Hmm. 650.
652.
Hmm.
The act starts at Lordship. It starts at page 647.
Hmm.
This is 2011 act. This has been set aside now. Identical act has come in 2000.
Hmm.
In 2017, here page 652. Section 3, eligibility criteria for selection of educational institutions for provincialization of services of its employees. Here, the school at serial number subsection 3 says, the concerned educational institution must have the required infrastructure in case of degree college to which the college is affiliated. If it is a primary as specified in item 2 of the so-and-so right to free education. And in case of all other educational institutions, the concerned institution must have the required infrastructure as specified in section 10 of the Assam Non-Government Educational Institution Regulations of 2006.
Hmm.
So there is a correlation and connection between all these
Okay.
things.
Yes.
So regarding 10 Lordship, my submission is that the existing schools are not affected
Not
by this
affected.
amendment,
Okay.
where we want that they should own and possess so that there should be a control
Hmm.
mechanism to restrict the persons having not having land to establish this kind of schools.
Okay.
Now, section 28, the submission of my learned friend lordship, that the teachers cannot approach for appeal, 28A.
Yes.
So 28A, may I read it, lordship? Any government educational institute, non-government educational institutions or any individual non-government organizations, society or trust, as the case may be, establishing any non-government educational institutions agreed by the order of director, passed under any of the provisions of this act, may prefer an appeal before the state government against the order of the director within 30 days and from the date of receipt of such order. Decision of the state government in such appeal shall be final and binding on all concerns. So on the basis of this language and the provisions of 28A appeal, my learned friend submitted that the teachers have no
Remedy.
remedy. That remedy I have already placed, the educational tribunals.
Hmm.
It was already established in 2016. And lordship, on that day, when I placed it, and lordship, what about the school authorities? The school authority is covered by appeal. So far as teachers are concerned, the educational tribunals.
Education time. Right.
So there is no difficulty in providing them the legal remedy.
Okay.
So this argument will also not hold because there is a separate
Tribunal
tribunal,
is functional as on date.
fully functional and very vibrantly functioning.
Okay.
And after that, the repetitions are coming from the tribunals.
The
order.
district judges have been given the power.
Yes, lordship, all districts, lordship. The large number of cases are pending there, lordship. It is effectively functioning.
Where is the act? Can we have a look at the act? Is it there in this book?
It is a notification, yes, page
Page?
1,
One.
yes. Regarding functioning of educational tribunal.
No, but where is the act? Act. There
Tribunal.
must be a time.
No,
State.
this is in terms of a division, a full bench order from this honorable court. Because at that point of time, lot of teachers came before this honorable court being in private schools. So it was not considered to be not maintainable. There are two opinions of two different division bench.
This query is coming because in Rajasthan, there is a proper act. Rajasthan State Services Appellate Tribunal Act.
Amar ase?
There must be an act. There must be an act.
We have Assam Administrative Tribunals Act is there.
So under that only the
There will
tribunal.
be
No, but whether these tribunals have been constituted in that, if the tribunals were constituted under that act, the district judges would not be the presiding officers.
No, we have this administrative orders, lordship, 162. This order, may I read it, lordship, the language? In compliance of the order dated 19th March 2015,
But Saikya, we are just saying this.
lordship.
Why can't you form a formal structured kind of system
If lordship
whereby the
order-
tribunal can be a proper body under the Tribunals Act rather than it being under the this is a stopgap arrangement, basically.
Yes,
District judge,
we can
supposing
always,
a district judge has got 1,500 cases in his court, the regular cases, how would he handle these cases?
that way, lordship, I do agree, that is number one. And number two, there are other like that mental health authorities also. It has also been delegated to them.
So, rather, it will be better that
We'll
you
do it.
have a proper tribunal for the service disputes of the state government.
If the
employees.
judgment, lordship may give some indication that
Even this
lordship may
can,
desire that, then we can definitely take it forward.
we will like to make,
Yes.
because this should not be interlinked, basically.
In
These
any case,
functions of
lordship,
the,
At this stage,
presently what you say is
presently
that they
there
are
is a
functional.
system in place.
There is a system in place, right?
So this 28 will also, in my humble submission, will not hold. Now coming to section 20. The section 20 is lordship.
20.
Inspection and supervision. Here, one part, lordship, the director or any officer authorized in this behalf may enter at any time with or without notice any place or building or premises which she has reasons to believe is being used as a non-government educational institution. So here, the director must have some reasons to believe. He must have that opinion.
Okay.
So my humble submission is that this is not in respect of the schools which are completely following the norms by registering them. Those who are registered, lordship, there is no scope of invoking 20A. That is
So
my
you
first
mean to say
submission.
that this requires an interpretation, that it doesn't apply,
It
to-
has not applied, it
it
has
does not apply
registered.
to registered schools, it would not apply.
It will
So
not
the
apply.
director will not be able to enter a registered school, even if there is a violation.
That
is why we
that is
said-
guided. I'm coming, Lordship. That is one part.
Hmm.
That regarding 20A,
Hmm.
my submission is that those which is a registered school, it is already under the system.
Hmm,
Those what should be his reasons to believe
hmm,
that particular premise is used as a non-government educational institution.
hmm,
He can inspect the other schools, Lordship, to verify whatever they have stated. Suppose they have stated they have 3 acres of land.
hmm,
In that situation, he can verify it through by himself or by his authorized officers,
Okay.
whether actually what they have stated in their scheme or management scheme,
Hmm.
Lordship, that is correct or not, for verification purpose. Number 2, to make such examination of place, building or premise, or inspect any place, building or premise equipment, etc., including financial transactions, and seize any of such equipments, articles, documents deemed necessary for the purpose of examination, investigation, or collection of evidence, and retain them as long as necessary.
hmm.
And after making the inspection, the director or his officers carry out the inspection, shall furnish a copy of the inspection report to the manager this should be of managing committee of the non-government educational institution to act upon the report and for compliance thereof. So this is the provision in the act, but we have to read it with the provisions of Rule 6 of the rules.
Hmm.
It is not in isolation, Lordship. Rule 6, Chapter 4, page 601.
Hmm.
Enquiry and inspection. So these are the guiding principles. There are three situations which are contemplated under the act and the rules in which the enquiry and inspection by the director or his authorized officer can make. Rule 6 says, enquiry or inspection for registration and administrative recognition of
So
existing.
this is pre-registration procedure. This
Yes.
deals with pre-registration.
Three situations I'm saying.
Hmm.
This is one situation when the inspection can take place.
Hmm.
After provisional registration of the existing non-government educational institutions under subsection 2 of section 6 of the Act, the director shall make or cause to make an inspection by officers authorized by him to ascertain the existence of the non-government educational institution applying for registration, and also to verify the correctness of the particulars
Hmm.
and information furnished by the management authority in application form, including academic and other facilities provided in the institution.
Hmm. Yes.
The inspection officer shall prepare and submit a report in Form 4 for consideration of the director. The director shall place the inspection report before the Administrative Recognition Committee along with other relevant documents for its consideration and administrative recognition and final registration. Pausing here for a moment, what is required to be verified? That is in the scheme. That scheme, Lordship, will find a scheme has to be made under Rule 16,
Hmm.
page 605.
Hmm.
Scheme of management under section 14 of the Act.
Hmm.
Each and every non-government educational institution shall prepare and submit to the director a scheme of management where they will indicate all these things regarding the power and function of the secretary, etc., including the classrooms, fees, everything.
Yes.
So those situations has to be verified. And for that purpose, this 6(1) is contemplated. Now coming to the next situation. 6(2). Inspection for the purpose of administrative recognition of institutions established with prior permission.
Hmm.
So first one is for the one situation. The second situation, the director or his authorized officer may conduct inspection of non-government educational institution established with prior permission and duly registered for the purpose of administrative recognition as required under subsection 2 of section 5 of the Act, and prepare a report in Form 4. The inspection report shall be placed by the director before the administrative recognition committee for the consideration. So he have to just verify and give a report to the committee for further action. The statements, the particulars given by the school authorities is finally verified and for taking a decision by these various committees. One is Administrative Recognition Committee, other is the Registration and Administrative Committee. This committee will take the call, but the director is the fact-finding authority, basically. Now, the third situation, inspection and supervision or inquiry of institutions on other occasions. The director or his authorized officer may conduct inspection and supervision or enquiry of non-government educational institution as and when necessary by giving or without giving prior intimation. Other situations, it's a general one. Now coming to the guidelines. General guidelines for inspection and supervision. Normally, the inspection or supervision shall be not be a fault finding of teachers and management, but it should be helpful in the form of concrete suggestions for improving of teaching, learning process and overall functioning of the institution. That is one situation, visualize. Next is guide the institution in organizing of co-curricular activities necessary for all-round development of the students. General one. And C, to ensure implementation and observation of these rules and provisions of the act in letter and spirit. So whatever is there in the act and the rules, Lordship, within that parameters, within that framework, he can do the inspection and supervision. Now, only thing is that which is troubling in my humble submission is that whether he should have the power of seizure or not. That power of seizure,
It doesn't fit in with this scheme of things, basically.
a scheme of
That's
things.
what we feel. Prima facie, that is the opinion. That, yes, collection of information, all right.
Verification of information also.
That is perfectly right. That is,
Lordship.
but seizure,
Regarding seizure,
yes.
in very rarest of the rare case, Lordship, that may take place.
You
And that is also subject to judicial scrutiny. That is what is I am subject.
you just can't give the power and expect that, yes, we will presume that will be done in the rarest case.
There are various acts, Lordship, have verified. There are some laws relating to the penal action like the Drugs and Narcotics Act.
There, of
Those
course,
there we have.
seizure.
But in the stamp
There the
act also,
seizure
in the
has to be
revenue
there.
acts also, in the revenue acts, this Assam value-added tax have that power.
That,
Assam
they all
state
have
tax,
penal provisions, Mr. Saikia.
Then central
They-
stamp,
those-
the central stamp act and the revenue act, that has.
They
that
all
power,
have
not penal provision.
consequential financial penalties.
Here,
Financial
one
penalties.
angle is there, Lordship, that
Yes.
we have to check profiteering and commercialization. of
All right.
education.
That can be done very well by getting the information.
That
As on
also-
date, everything is online.
This is my submission, Lordship. may
Yeah,
always
we'll-
read down
we'll
this
take it.
provision on that particular issue of seizure.
We'll take note.
Yes,
No, we'll take note of your argument.
yes,
What is the purpose behind this?
yes.
Giving the power of seizure.
Yes.
We'll take
Now
note of
coming
it.
to another submission. So this
Yes.
is my submission regarding seizure and the inspection and supervision.
Yes.
So in my humble submission, there cannot be two opinion that whatever he is doing, it is a verification and fact finding exercise.
That
It
is,
is not an exercise to put or harass the authorities of the school. Now, under section 14, there is a submission. I'm coming to, I'm going serially, Lordship. Now, section 22.
14 subclause 3, there was an
Yes,
argument.
that
Mr.
was an argument that I'm conceding because when this was challenged.
Overlapping, at that time, they,
Overlapping, and he has practically no role.
No
because
role
He's
to
a
play.
part of it. Absolutely no. That it has come to our knowledge. If Lordship set aside, we have a happy. But if Lordship do not set aside, then we are going to amend it. Because
what we are, the discussion is very open. We have given out our opinion. Basically, this entire system of yours needs an overhaul. That's what we are saying.
my humble submission in two,
Because
three areas.
with a flex
two, three
of
very
time-
limited areas.
A flux of time, things have changed. This act of yours, even with the amendments, doesn't take those
No,
changes.
In 21 also, we have taken that amendment.
That's what we are saying. That why stopgap arrangements? Why not
Now,
a
one thing,
consolidated?
Lordship, only in respect of 2, 3 schools, this act is not applicable. In respect of all other 99% of the schools, this act is applicable. And they are following this act and we are doing
We
access.
understand, but there are provisions which need some dressing down. So if there can be a consolidated act,
The constitution has gone so many times.
Yes, yes,
103
yes.
times, 104
Precisely,
times.
precisely.
It is not a static thing. It
It's
is a
never-
dynamic,
it never can.
dynamic concept,
it
Lord.
never can be. Yes.
Yes.
All right.
So far as 3 is concerned, I
Hmm.
have already noted
Yes.
that this is not helping anybody's case.
Hmm.
What is stated here, the director may approve or disapprove. So when it was incorporated,
At that time, it was not
there
there.
was that 2016 act was not there, rules
It
of
was.
2017 was not there, and they have not deemed it fit to amend this writ petition also. So now it has become redundant.
It's
has become
almost redundant. Yes. Yes. Okay.
So this has become redundant. So
Hmm.
there is no, but one thing is that in the management of scheme,
Hmm.
they have to incorporate that. If Lordship is pleased to see rule 605,
Hmm. Yes,
605 section,
Rule
rule
16.
16 I.
yes. Hmm.
Students fee structure indicating rate of admission.
That is,
That is required, Lordship.
that is collection
just
of
the indication.
information. Collection of information.
Yes.
Maybe if they are deviating, the director will inform that
Exactly. The
Committee.
fees regulatory authority.
authority.
Because they are, suppose they are taking sports fees and they are not doing anything. They are incorporating here and the verification says that there is no playground, no sports activities.
That's right,
in
that's right.
That has to be informed and director is a part of that fees regulatory committee.
Hmm, hmm.
So this information may be there, Lordship, but
Hmm.
3 may be set aside.
Fair
I'll
enough,
not say
fair
the set aside, Lordship may read it down.
fair enough.
Now,
We are not recording any concession rest session. Yes.
now coming to section 22,
22.
page 590,
Hmm,
592, Lord.
hmm. Audit and accounts.
Audit and accounts.
Hmm,
They were unhappy with the provision that why this annual report has to be submitted to the director.
Hmm.
That is required, Lordship.
hmm.
Just to see that there is no profiteering, there is proper using of the funds. The funds, how it can be used, that is also given in the act and the rules.
Hmm,
There is absolutely no other role of the director here.
hmm.
The accounts of the non-government education institution shall be maintained and the audit shall be done as in a manner prescribed. So that is by the formal auditors.
Hmm.
The institution shall furnish to the director an audited statement of accounts. At the closing of every financial year, mention clearly the total receipts and expenditure during the last financial year. So this is a record keeping exercise, Lordship.
Okay.
The director cannot have any role if he feels that it is not in commensurating with the projection they have done before the fees regulatory authority or fees revision committee.
Hmm.
Then he being a part of it, he can brought it to the notice of those committees.
Okay.
So this is just furnishing of the materials. This which they do before all other authorities, statutory authorities.
That everyone has to do.
Yes, Lordship.
Hmm.
So in my humble submission, there cannot be any illegality or unconstitutionality on the part of the director of receiving this or demanding this annual
Hmm.
audit report.
Okay.
So 22 is gone, Lordship. Now 24. Withdrawal of recognition, order or closure. Where any non-government educational institution fails to fulfill or comply with the provisions of the act or violates any of the provisions of this act or the rules made thereunder, or any order passed by the state government or the director under the provision of this act, the state government may at any time after giving reasonable opportunity of being heard, order for withdrawal of administrative recognition and closing down of the non-government educational institution. In the event of such closure, the individual association or association of individuals, non-government organization, society or trust establishing and running the institution shall be solely responsible to the teaching and non-teaching staff, students, guardians, parents, and other concerned persons and bodies. 2. The non-government education institution established and functioning in the state without being registered under section 4 shall be liable to be closed down, and in the event of such closure, the individuals, they will be responsible. But it is not abruptly will close it. There is a process that first will stop the admission for the next year. And the students who are studying in that till they complete their courses.
Is there any procedure provided? in-
Yes, that is there.
In the rules?
No, yes. The other day I placed it, Lordship. Immediately it will not stop the closing part. During the course of hearing, I'll place it, Lordship.
Mention it in your written submission.
Yes, Lordship.
Okay.
So 24 is gone, Lordship, now.
25.
25, there is no such sufficient from the other
That
side.
was our observation, Mr. Saikia.
Lordship,
punishment.
liability of the chairman to
Punishment.
punishment.
No, who gives the director to impose a punishment?
Any
Without there being
non-government educational institution, they are not
offense.
failing to comply with any direction issued to it by the government or the director in discharge of their duties under this act. The chairman or president or society or trust of the individual association and individual, etc., for overall management of the institutions or the owner thereof shall be held responsible and be liable to be punished with a fine which may 10 to rupees 10,000 for the first offense and in the event of.
Offense. No, where is the offense defined?
Yes, Lord.
This is not a happily worded section, Mr. Saket. And there is no procedure. Who will punish? Who has been given the
Just,
power to
Lord,
punish?
Just 1 second, Lord. Somehow I missed this
So
because there was.
This was a clear observation when
Yes.
you were reading the act, we made that observation. Maybe it might have slipped your mind. Where is the procedure for conducting this, undertaking this exercise under 25? And you don't define an offense. That's, if you recollect, we made that observation, that there's no definition of an offense. Who is the adjudicatory authority for this offense? Come to 21, rule 21
Yes, Lord.
and
For
19.
all others, there are procedures.
Yes, for this there.
For the
there is-
teachers and employees also, there is a
Yes.
procedure laid down.
Exactly. But for 25,
Up to section 16, there is a procedure laid down. Then
Yes.
the funds of the institution maintenance, that is the rule. Then admissions 18. That is a gray area, Lordship, in my humble submission.
that is
So
a gray area
whatever is
because
not there, I
there is
will
no
not.
procedure, there is no definition of an offense.
But an exercise is there, section under section 24.
That is withdrawal of recognition, we understand.
Yes,
But you know.
regarding the
that
punishment.
What you have done is,
Yes,
you see, because closure is a very drastic act. So power has not been given to the director. Their argument was that there is no appeal against this under 28A. Because the state takes that decision, not the director. 24.
yes, that is but the state.
So
So for a
your
punishment, who
argument
is the
was
authority?
that the remedy would be filing a writ petition, 2 to 6, against the order of closure.
No, they have a provision for appeal also. If it is
They
24.
appeal against order of 28,
Yes,
state,
yes, state, they cannot,
they cannot.
they cannot. So it is to, it's a very rare case, Lordship.
It's like, when you are coming out with an act, you can't.
No, there are a lot of areas, Lordship. I have gone through so many judgments. In lot of areas, new situation develops. Now, after this act, how many schools are closed? Not a single, if I am not
Act
wrong.
can't be tested on those yardsticks.
But
Act
the
has to
thing is
stand
that
or
when an
fail
act is prepared,
on.
when an act is prepared, Lordship, all situations are not visualized. Now, why
Ideally-
226 is surviving till date?
Ideally, it has to be done. It is not done, that's a different matter.
Lordship, why 226 is flourishing? Because there are a lot of areas, gray areas.
Ingenuity of the lawyers.
That is one aspect. Why 309 is there? Article
Yes.
309 is there. Because the government has failed to have the service regulations
That's right.
through an act or rules. So there
So
are, and
there are
in-
some,
and there are some certain principles.
yes, that's what, while discussion, this is just a very good academic discussion kind of thing going on.
That they
At
will
that
not consider it as an academic discussion. I can participate in academic.
They may think whatever they like. That's they were right to think.
They will
in
argue
their
on
own-
my discussion
But-
points.
But what we feel is that this, at over a period of time, some things have become stale.
Absolutely.
Some
Lord.
things were defective right at the beginning. So it's just an observation,
Lordship.
loud thinking. That even after the arguments, if you can come out with a suggestive measure of changes, suggestive changes on behalf of the state,
No difficulty.
it may work out well for all concerned. That's what our loud thinking is, subject to what the decision.
No difficulty, Lordship.
Okay.
Regarding
this
regarding the punishment,
Punishment.
the rule is totally silent. Neither the authorities who can impose punishment, that is
Yes,
also
yes,
silent.
Yes,
So we have to do it, Lordship.
yes. Okay, so that takes care of 24, 25.
24 is already taken care of,
Yes.
Lordship. 25. 25 is,
24, the only question we posed you is that there's no remedy of appeal against this closure.
yes, there is no provision of appeal, but there is 226.
226. only.
And I'm not sure whether education tribunal can also look into it. Very.
That is for the employees. That is why we said
Yes.
that a proper act under the Administrative Tribunals Act,
So
proper tribunal, that would take care of these things also.
that is
maybe.
educational tribunal,
Uh,
but we have the Assam Administrative Tribunal also. where also when the educational tribunals were not functioning,
Hmm.
the AAT, Assam Administrative Tribunal was taking up those matters. And in some cases in the in between 2008 to 2012, there are a lot of directions from this honorable court sending the writ petitions to the tribunal.
Yes,
In
we,
spite of the,
in Rajasthan regularly that is happening.
yes, that
The
is
services
happening.
appellate tribunal is there.
So there is a already a forum, Assam Administrative Tribunal.
Recently under our directions on the judicial side,
Lordship.
a bench has been established at Jodhpur.
But here. it was
Services
only
appellate
there, it
tribunal.
was from 1989. I
Yeah,
think
no.
that
The tribunal was functioning at Jaipur. So we
Lord.
directed a bench to be constituted at Jodhpur.
Lordship. So here it is hardly a half kilometer where the tribunal is functioning.
So
But
this-
still people do not go, they prefer 226.
That's right.
That
That's
is
right.
effective.
Because we had to throw out the people. What happened was that during transfer seasons, the tribunal was not functioning at Jodhpur
Lordship,
and the matters could not be taken up. Then there was a deluge of writ petitions.
absolutely.
For that, the court was forced. Now with the formation of the bench, things have eased up.
During the COVID time, Lordship, the CAT was also, the Central Administrative Tribunal was not functioning. So a lot
We
of
had
cases
to
were
entertain
entertained.
the DRT. We saw
Here they
that
are same
situation.
thing, Lordship.
Same situation we saw.
Same.
Okay.
So now coming to the next provision,
26.
26 Assistant Self Police Administration.
Mm.
So director may, as and when situation so demands, takes the assistance of such police force or assistance from the civil. This is a situation which is not visualized under normal circumstances.
That's why we say that when we are considering the language, there has to be a very, because this is a very drastic measure. So there have to be
There is a
pertinent,
drastic matter, Lordship. The
pertinent
thing is
either
that
in the rules. It's like, yeah. You see,
Lordship,
you,
Lordship will have to look it from that perspective. In Assam, still about in 7 districts, the Special Armed Forces Act are in force.
Mm.
Assam was a disturbed area. All these situations, and there are certain areas where Lordship will.
no, we
go
are
and-
not saying that you just remove this.
This situation is,
measure.
this situation will not arise.
But there
in
has to
Guwahati.
be, just as you gave out guidelines in 16, rule 16,
Yes.
there have to be specific guidelines even for the director, when he would be able to.
Suppose I'm just visualizing a situation in Guwahati itself.
Mm.
About 5 years ago, one student jumped from a school in Silpukuri, which is about 3 kilometers from here. In that situation, whether the director, because
That is role
that
of
is
police.
one incident. There is another incident.
That is role of police. 176 comes into picture. In Kota, 22 students from one particular institute
Yes.
committed suicide
There is a very
in this
recent
year.
one, Recent one.
This year,
This very
23.
recent one.
so but that doesn't give any power to the educational authorities.
So
So what we are saying is that for this
the
purpose,
police will
there
go.
have to,
Police will go. Lordship. One thing is that police going and investigating the criminal offense, but that is
that,
perfect.
that there is a
But
power of the
whether-
CRPC.
Suppose the student went to the roof and there is no boundary,
Hmm.
whether the director can go inside and verify it or not.
Director can very well go.
If the school authority is not allowing the director to enter, then in that situation, what will happen?
Mr. Saikia, come back to the earlier provisions. You will not grant recognition without verifying the safety.
No, that is safety. There are certain evolving cells. Suppose they have
Yeah.
constructed a phrase.
What we are saying is that there have to be particular, as you have given out in 16, there have to be particular guidelines in rules, indication in rules, under what situation, because this is very wide and uncontrolled.
No, it is controlled because I am saying that it is not only the police. Lordship will kindly see.
Civil administration, yes.
What
Minis-
is civil administration?
Municipal authorities, you said earlier other day, municipal authorities,
No.
sanitation facilities.
Those are there.
Yeah.
But civil administration is the deputy commissioner. What
Hmm.
do you generally think is a district administration?
Hmm.
Who deputes a magistrate,
Executive magistrate.
as a executive magistrate.
Hmm.
So if the police enters also with to help the director,
So
Lordship,
there
there
has
will be a
to be,
magistrate.
there has to be some structure to this provision. That's what we are saying.
Yes,
That's all. There has to be a guidance
Yes.
under what extreme situations
yes.
this position is
I
counted.
fully agree, Lordship.
That's all.
There is no objection from my end, Lordship, to
Okay.
that.
Very well. So that takes care of all provisions
Yes.
of act.
In all provisions. Now, my learned friend, Mr. Nair argued that there is a conflict or there are overlapping with
Overlapping.
RT Act.
Hmm.
His writ petition was filed in 2008.
Hmm.
RT Act came in 2009. And the other writ petitions, there is not a single whisper of RT Act. RTA takes care of students up to 14 years and up to class 8. The schools which my learned friends are representing, they are much beyond class 8. So that argument in my humble submission, I do not have to counter because they have not pleaded number one. The previous case, Lordship was like, where is the pleading? Here
Yes.
also, I could not find a single word of RTA Act in any of the repetitions.
Yes,
CBSE, ICSE, SEBA, these are the boards here.
they are the boards.
They all have classes up to class 12.
Hmm.
So a school, we are not bifurcating it to elementary and secondary. What schools they are representing, these are all secondary schools. So RTA Act in my humble submission is not directly applicable, number one. And there is in my humble submission, the rules and the act. Also, there is no conflict. But as there is no pleadings to that effect, I do not deem it proper that they says that the petitioner school comes under 2A4 under section 18. Then the school management committee should be constituted under rule and section 21.
Yes.
All these arguments, Lordship, will not hold because we have to compare it to a proper pleaded case. That is not the situation here. On top of that, Lordship, I have already submitted my submission regarding the inspection and seizure. And so far as my learned friend, Mr. Borbora is concerned, Lordship, the senior counsel, it is basically the reiteration of whatever was argued at the first round, and I have elaborately dealt with in my first round of arguments, Lordship. So I do not want to add anything, whatever I have submitted, Lordship. And one judgment was also taken, Lordship, by my learned friend Nair, 1989. That is not relevant because he cited the judgment in the context of RTA Act. So that is not applicable. I have already placed, Lordship, the judgment which I am going to rely.
Yes.
So basically, this is my submission. If there is some gray areas, Lordship, we are ready to rectify it. If it comes in the observations, it will be immediately taken care of.
It
But
would be nice if you can-
regulation is required. Regulation,
Regulation-
registration.
Nobody can dispute that.
Absolutely. Then
Nobody
that is
can
my whole idea, Lordship, that there should be some regulation. There should not be profiteering. The students should be properly getting all the facilities for which they are paying. The teachers should not be randomly thrown out of service. They should not be given meager salaries. And
Yes.
there should be a proper academic atmosphere prevailing in this institution. It should not be a commercial entity. Research should be a educational institute, which has been mandated by series of judgment from TMFI to Ansari's case. All the cases are saying that this is a charitable exercise. If you want to do proper business, go to a proper forum, proper entity, but through education, it cannot be a huge profit-making exercise. The money which you earn or which is excess after the expenditures should be pumped into for the development of education and for the institution. So in that view of the matter, there is no illegality, no unconstitutionality. There is absolutely a justified legislation, Lordship. There may be one or two deviations, Lordship, which can be rectified at any point of time. This is my humble submission. In that view of the matter, all the petitions may be liable to be dismissed. Lordship.
Okay.
Highly obliged.
I'll make a short rejoinder. And we'll place one or two more cases in addition to the cases I cited and placed.
Lordship, may I take a leave?
Sure.
And thereafter, my lord,
By what time the written arguments will be coming?
Yeah.
Mr. Mazumdar.
I have already completed, Lordship. Tomorrow I'll submit it. Whatever submission I have made, I'll just edit.
Okay, thank you.
So, my lord,
Along with that note of the fees regulatory regarding the minutes of the meeting.
so my lord, I will not take more than 15 minutes. Thereafter, my lord, Mr. Nair will conclude the proceedings subject to any last minute query by your lordship. That's my idea, and it should be finished by 1 o'clock, I suppose.
Yes.
My lord, on seizure, I cited certain decisions, my lord. Now, one decision of 1960 Supreme Court, page 554, 5 judges.
Yes.
I am fond of referring to all judgments of 60s. Old is gold, my lord. And these are still holding the fields. 5, my lord, paragraph 36 and paragraph 37, I will refer on search and seizure. Page 554. Lordship may come to page 36, paragraph 36.
Yes, please. Yes, carry on.
Yes. The constitutionality of section 8 of the Act was challenged on the ground that it violated petitioner's right under Article 21 and 31. Section which quoted runs as follows. Any person authorized by the state government in this behalf may at any time seize and detain any document, article, thing which such person has reason to believe contains any advertisement which contravenes any of the provisions of this Act. And a court trying such contravention may direct that such document, including all copies thereof, article or things shall be forfeited to the government. It was pointed out by Mr. Munshi that there was no limitation placed on, no rules and regulations made for, and no safeguards provided in regard to the powers of a person authorized in that behalf by government to seize and detain any document, article, or anything which in the opinion of such person contains any advertisement contravening any provisions of the Act. It was also submitted that in the corresponding English Act of 1939, section 10, there are proper safeguards provided in regard to the exercise of power of seizure, etc. The first part of section 8 of the Act dealing with seizure detention received slender support from the Solicitor General. It may be, he contended, that having regard to the purpose and object of the Act of the Indian legislature did not think it necessary to provide any safeguards, and that the legislature thought that nobody would be prejudiced by reason of want of safeguards previous to the seizure. In our opinion, now the court says, this portion of this section goes far beyond the purpose for which the Act was enacted, and the absence of the safeguards which the legislature had thought it necessary and expedient in other statutes, as per example, the Indian Drugs Act, is an unreasonable restriction on the fundamental rights of the petitioners, and therefore the first portion of this section, namely, quote unquote, any person authorized by any provisions of this Act is unconstitutional. What then is the consequence of this unconstitutionality? If the portion is excised from the rest of the section, the remaining portion is not even intelligible and cannot be affirmed. The whole of the section must therefore be struck down. Then paragraph 37, by a portion of clause D of section 3 and the whole of section 8 being declared unconstitutional, the Act is not thereby affected as they are severable from the rest of the Act. This is also doctrine of severability, which I argued, I will come, of the Act. The operation of the remaining portion of the Act remains unimpaired. It has, my lord, made a reference to the 1957 Supreme Court judgment, my lord. That judgment has been subsequently until date relied on by the Supreme Court whenever the question of doctrine of severability crops up. So in this case of my lord, however, the entire Act was not challenged. In this case, only a particular section, namely
The
section.
entire Act was challenged, but the Supreme Court affirmed the challenge to one provision partly and one fully. Yes.
So therefore, my lord, so far as section 20 of the Impugned Act before us, my lord, it has, my lord, not been guided, and it is not, my lord, that it has not necessitated for taking a warrant of search and seizure from the any court of law. A director can simply get inside the premise and then seize, my lord. This is, my lord, opposed to section 93 and section 100 of the CRPC, and also 103 of the CRPC. Only under that, those provisions, my lord, the search and seizure can be effected. Section 93. উনি বলে মার দিয়ে হয়ে যাবো দেই।
Yes.
Section 93, when search warrant may be issued, where any court has reason to believe that a person to whom summons or order under section 91 or requisition under section subsection so and so of 92 has been or might be addressed will not or would not be produced the document or things as required by such summons or question. Here, the satisfaction or the belief will have to be by a court of law, subsection 1, not by even any officer, my lord. Where such document is not known to the court to be in the possession of the person, nothing, last I am reading 2 and 3. Court may, if it thinks fit, specify in the warrant the particular place or part thereof to which only search or inspection shall extend. It will confine the area
Yes.
which can be entered upon, searched, and where from seizure any could be made, not the entire premise. And the person charged with the execution of such warrant shall then search or inspect only the place or part so specified. Nothing contained in this section shall authorize any magistrate other than a district magistrate or chief judicial magistrate to grant a warrant to search a document, parcel, or other things in the custody of. Then 100, section 100, my lord. Even courts are restrained, my lord, to a great extent while issuing a search warrant. 100. Persons in charge of closed place to allow search. Whenever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of the officer or other person executing the warrant, and on production of the warrant, allow him to free ingress into and afford all legal level. So one, I am the owner of the house. I may refuse him to enter into my premise, ingress into my lot, unless he produces a warrant, shows me a warrant issued by a competent court of law. So I will not read. Then this section also goes like this. Even the court's power is also very restrained. That's what I am trying to point it out to your lordship, my lord. Section 103. Here it says, any magistrate may direct a search to be made in his presence of any place for the search of which he is competent to issue a search warrant. Here, my lord, magistrate under CRPC means my lord a judicial magistrate, not even executive magistrate. So this is about it. And this power vested on the director under section 20 is my lord reminiscence of the powers given to a commissioned officer under the Armed Forces Special Powers Act, where if in his subjective opinion, he forms an opinion that, well, that man on the street might commit certain unlawful things, he can shoot at that man. So this power vested to the director as unguided and without authority of law, my lord, is reminiscence of the powers given to Armed Forces Special Powers, which even the government of Assam is presently declared as to very soon it will be withdrawn from. And on the question of my lord, appellate provisions on not prescribing any forum of appeal against any action or order by learned friend, my lord, has Advocate General has shown substituted provision 28A appeal. Where that action is by the director, you can go to the state authority, commissioner with the appeal. Now, section 24, I will not again read it, my lord. Lordship has already seen that there are provisions where the order, where a school is aggrieved of, is passed by the state. Then where
Then the school has the opportunity to engage Mr. Barbara and come before us. What is wrong in that? So that is actually restraint on the power of the director. Director cannot direct closer. The power has been given to the state government. So that is a very reasonable provision.
Here again, my lord, I will cite, my lord. One case I cited that day, my lord. Another old case, my lord, 1964 Supreme Court. I want to cite, my lord. Yeah. Yeah, 1964 Supreme Court, Calcutta Corporation, my lord. Page 1279. I'll refer to my lord. This is also 5 judges. Paragraph 6 and 7. Only 2 paragraphs I'll refer. paragraph 6 at 1281.
Yes,
It is in an old case, my lord, Corporation of Calcutta versus the Calcutta Tramways. 6.
Hmm.
We must therefore proceed to consider whether in the circumstances of this case, the restriction obtained in the parenthetical clause in 437(1)(b), this was under challenge, my lord, of the Corporation Act, by which the opinion of the corporation has been made conclusive and non-justiciable, can be said to be a reasonable restriction on the right to carry on trade, etc. Enshrined in Article 19(1)(g). In Dr. So-and-so 1950 Supreme Court held that a law providing reasonable restrictions on the exercise of the rights conferred by Article 19 may contain substantive provisions as well as procedural provisions, and the court has to consider the reasonableness and substantive provisions as well as the procedural part of the law. My lord, when the constitutional deposing here, when the constitutionality of any state or parliamentary act is under challenge, two things will guide the courts, my lord, your lordships. One is substantiality and other is the procedural part. In this case, I submit that both parts have been violated. Then I continue, my lord, paragraph 6. The parenthetical clause which makes the opinion of the corporation conclusive and non-justiciable is in the name of a procedural provision, and we have to see whether in the circumstances of this case, such a procedural provision is reasonable in the interest of the general public. It has been, I'll, my lord, skip this portion, come to the marked portion, my lord, below. It is marked on the left-hand side. The vice in the provision is that it makes the opinion of the corporation, howsoever capricious or arbitrary it may be, or howsoever unreasonable on the face of it, may be conclusive and non-justiciable. The conferment of such a power on a municipal body, which has the effect of imposing restrictions on carrying on trade, etc., cannot, in our opinion, be said to be a reasonable restriction within the meaning of 1906. Such a provision puts carrying on trade by those residing within the limits of the municipal corporation entirely at its mercy, if it chooses to exercise that power capriciously, arbitrarily, unreasonable, though not mala fide. We therefore agree with the High Court that the conferment of such power on the corporation as it stands in the parenthetical clause in section 437(1)(b) must be held to be an unreasonable restriction on the right to carry on trade. Then paragraph 7, my lord. This brings us to the next question, whether parenthetical clause is severable from the, now, my lord, we have seen, my lord, there are violations in innumerable sections and subsections. Section 18, section 14, section 21, section 20, section 28, in such a situation. This brings us to the next question, whether this parenthetical clause is severable from the rest of the provision. In this connection, it may be observed that in the Calcutta Municipal Act 1923, which was repealed by the Act, the corresponding provision was contained in section 386, and there was no provision making the opinion of the corporation conclusive and non-justiciable. In similar provisions of the other two laws, there is no provision making the opinion of the corporation conclusive and non-justiciable. The Supreme Court was comparing, my lord, the other acts, my lord. In the Madras City Municipal Act, there was a similar provision in section 287, with schedule so-and-so, which provides for license where a place was used for any purpose in the area, which in the opinion of the commission was likely to be dangerous to human life or was likely to cause nuisance. Similarly, in the Delhi Municipal Act of 1957, there is a provision in section so-and-so, which provides that no person shall use or permit to be issued any premises for any purpose, which in the opinion of the commissioner was dangerous to life, health, property, or likely to create a nuisance. We have referred to these acts and the provision in the Calcutta Act, which was the predecessor of the act, to show that it is quite possible to work such a provision without the opinion of the corporation being made conclusive and non-justiciable. The question therefore is whether this provision contained in the parenthetical clause 437(1)(b) can be severed from the rest of the provision. Now here, my lord, the principles of 1957, 628, it is again, my lord, discussed, 1, 2, 3, 4. These are the basic principles and parameters, 1957, 5 judges, my lord, which even in this year, 2023 is holding field, my lord, with all respect. So, and then in this court, by paragraph 13, the order of the High Court striking down the whole section must therefore be set aside, and here, but it has set aside. So in my humble submission is that in the Calcutta High Court also only section 437 1B was challenged, not the entire act. Not the entire act, and not even the other subsections of section 437. It challenged only one subsection and one clause. And therefore, my lord, I respectfully submit that the instant case on board before your lordship, we have an impugned act, which, my lord, contains innumerous provisions, in spite of the fact that during the pendency of the case for last about 12 years, government repeatedly tried to improve upon by bringing one after another amendment under the rulemaking power. Although there was a status quo on the day one, and whether the rulemaking power was under eclipse, I don't know, I am leaving it, and that is not my major point to argue also. They have the rulemaking power. But in spite of all these amendments, 28A, the word may was amended. So, taking all this together, even as the act stands in its amendment from today, contains, my lord, provisions which are, my lord, unconstitutional, unguided, arbitrary. There are some sections which, reading with their subsections, your lordships, I submit that they are self-contradictory, they are intra-virus, apart from being ultra-virus to other provisions, and unconstitutional. And therefore, by taking into account, my lord, the doctrine of severability, corollary, inseverability, squarely covers this case, and the entire act is liable to be declared unconstitutional. I conclude, my lord, by day after tomorrow, my lord, I will produce the
Written submission.
written statement, my lord. I have one argument from both me and my lord Nair. Now I leave it to Mr. Nair, my lord. Conclude. Obliged.
Lord, I had on the last occasion, my lord, extensively dealt with, I'll not repeat those, my lord. Only few points which I would like to just clarify. My lord, this tribunals that have been constituted were constituted as an ad hoc measure until and unless a legislation is made in terms of PI and the other cases. When they said there any dispute, you have a forum. Now, my AG has, my lord, referred to the Assam Administrative Tribunal. Assam Administrative Tribunal, persons of our colleges or schools, my lord, cannot go because there you have to be a civil servant. Thereafter, only a case can be filed.
Yes, yes.
This will not apply. And my lord, the problem here, just beyond this case, it's not a 323A tribunal, my lord. In Rajasthan, my lord has referred to the state administrative tribunal. 323A tribunal. This is not a 323A tribunal. This is a tribunal of 1977 created by the state legislature. So, my lord, it's not at par with those tribunals, be that as it may. Now, my lord would have only one thing which I would like to project, my lord. My lord, this section 14, which I, my lord, all along was saying was the heart of the matter. My lord, the section 14 as it stands, my lord, the object of the act is to, my lord, stop profiteering. Now, 14 entirely is covered, I have that day demonstrated, my lord, covered by the 2018 fee committee regulations, my lord. It takes into account the entire thing which 14 proposes to me. And 14, my lord, is connected to 16 of the rules.
Yes.
And therein, my lord, E, F, G, H, I, if I may say so, my lord, are also covered by the rules of, by the Act of 2018, that the fee committee rules. So, my lord, when a proper body is there, a complete code in itself, such provisions.
So tell us, Mr. Nair,
Lord,
that during the pendency of this challenge and
Lordship.
new act has come in, whether without there being a pleading, can we intervene in the provisions of that
My lord
on
can
the
take,
basis of a new statute?
lordship, my lord, I have to bow down, my lord, there is no pleading brought on record after this. But my lord, those acts are there on the statute book. My lord can always take judicial notice. These are legal submissions, my lord.
Yes.
Nothing factual here, my lord. These are legal submissions. And when those acts are there, which because one of my case before my lord with regard to this act is that you have given sections, but you have not defined the limits or the powers. Now, my lord, there is an act by the same legislature wherein, my lord, the scope and the procedure both have been in a detailed manner given. My lord will also have to take my humble submission that into notice, my lord. Because one of my challenge to this is, my lord, that this is arbitrary. Arbitrary because it names persons, but it does not define the role. My lord, the whole act, my lord says, the only thing which will be there is, my lord, recognition and prior recognition and administrative recognition. For that, there is something here. Beyond that, my lord, although provisions are there, there is nothing, my lord. And the appeal, my lord has read to the appellate provision. 24, my lord, is the penalty. And 28 is the appeal provided for them. Because, my lord, this is the only...
Not for 24. 28 is not for an order passed.
My lord, that's what I'm trying to say, my lord.
28 is restricted to the orders passed by director.
Because there is no order which will be passed by the director here. Because the core object here, my lord would see here 28, my lord. When my lord reads 28.
Why the director refuses to recognize?
My lord,
order challengeable under 28.
that is already provided for in that connected section, my lord, that you can prefer an appeal before the state government. Here, it is, my lord, related to 24. Why I'm saying so? If my lord can have the definition of non-governmental educational institution, 15 at 576, my lord.
Yes.
Non-governmental educational institution means school established, run by an individual or association of individuals or any non-governmental organization, society, trust, except the schools established and maintained by minorities under clause 1 of so and so. So my lord has got the definition. It only pertains to the person operating the school. Now my lord will have 28A, my lord.
Yes. Yes.
Any non-governmental educational institution or any individual, non-government organization, society or trust, as the case may be, establishing any non-governmental educational institution, aggrieved by the order of director passed under any of the provisions of this act, may prefer an appeal before the state government against the order of the director within 30 days. So, my lord, this 24 remediless.
24 is, they themselves say,
remedy.
Judicial review. Order of state obviously will have to come.
I'll have a power. But my lord, the act, which should be a self-contained code, my lord, does not envisage that, my lord. Whereas the other acts, my lord, has seen, there is a provision. You can go up on appeal. In the fee committee, from the district level, you can go to the state committee.
But then state committee, what is the remedy? State committee, the appeal.
I'll have to come back to your lordship.
So that's what
I'll have to come back to your lordship. But my lord would say,
yes,
here, this provision that has been given here, it's a provision given without that safeguards, my lord.
Yes, that argument we understand. No safeguards.
Lordship.
What is the procedure for taking action against
Nothing, my lord.
24?
Nothing for, and that also will apply to 25, my lord.
Yes.
Because 25
they have conceded virtually.
Lordship, I'll not go into it, my lord. So, my lord, if the act, my lord, finds the act to be not in the manner, act, because it should be a self-contained code in itself, my lord will not go into the rules. Because, my lord, the act, the state legislature must, that 89 judgment, my lord, which I had placed before my lord, the state legislature, while delegating a power to an authority, has to also give the limitations. That having not been given, my lord, I'm not saying that you don't have the power. The state does not have the power. I'll never argue, madam. State has the power. If it wishes that, because this is in larger public interest, they want to control. But by bringing in that control, if you're exceeding the authority given to you under 19(6), then my lord will come into the picture, madam.
Okay.
And the RTE Act, my lord, the Assam rules I have shown that day, at least this act, to the extent it applies to the elementary till class 8, my lord. This cannot have any jurisdiction because you yourself say anything contrary to the RTE Act, acts, rules, anything which has been operating, if can, my lord, can have the rules, my lord. The RTE rules at page 241, my lord. And relevant 272, my lord.
Yes.
30, repeal and saving. Well, this is the state rules under rule 80, section 18 of the, my lord, RTE Act. And I had shown that day, my lord, that rule-making power is again guided. For each section, my lord, they had said you can make the rules. The existing act, rules, regulation, executive instruction issued by the state government of Assam inconsistent with this rule shall be deemed to be void to the extent of inconsistency.
Yes.
And here, my lord, the control again has been made. Provisions have been made. I've taken my lord through that. I'll not take. My lord, in short, my submission would be, my lord, that it should be accepted that power is there. But if that power has not been utilized in a manner required, and you try to control into the day-to-day affairs of a institution, violating its right under 19(1)(g), then, my lord, that act, because it's not, this act cannot be severed, my lord. If my lord permits, if my lord takes out 14, takes out 24, takes out 28, my lord, then the only thing that will remain is the recognition and the administrative. Thereafter, my lord, there will be nothing with them to monitor the functioning of the institution, which cannot be intent of the act, my lord. Because whatever things have been fallen from the honorable, the learned AG, my lord, the sections which they say requires reconsideration, primarily, my lord, functions with the monitoring after recognition, my lord. If that is not there, then the object of the act cannot be satisfied and the act cannot remain, my lord. This is my humble submission, my lord. Much obliged.
Arguments have been concluded. Judgment is reserved. Arguments have been concluded. Then counsel for the parties are given liberty to supplement their arguments by written submissions within next 7 days.
Lordship.
Judgment is reserved.
No, next 7 days.
Judgment
Much
is reserved. Or-
I
Yes,
don't know, 4 and 5.
Yes, what is this about?
Your lordships. Well, this matter relates to reservation and promotion. The Act, Assam Scheduled Caste and Scheduled Tribe Reservation Act 1978 is under challenge, more particularly the amendments made in 2012. The writ petition was filed in 2013.
Is there any stay operating? No.
My lord.
Is there any stay operating?
No, my lord.
No.
Only one observation in the connected writ petition, that the authorities will not do anything contrary to what the Supreme Court has earlier said. So that is not a stay.
That's as such, there is no stay.
My lord, the
Mr. Chaudhary, we'll have to defer this one because the one which we already heard, that will consume a lot of time. And from tomorrow onwards, we'll be holding court only for this week, only till 1. Second half, we'll not be sitting. Will you be able to conclude today.
Today, my lord, the entire day, my lord.
Yeah, rest of the day, all of you. Because from
I-
tomorrow onwards, hearing matters will have to take a back seat.
My lord, so far as I am concerned, my lord, for placing my case, I'll take, my lord, hardly half an hour, my lord. But in reply, how much I have to say that I don't know, subject to what my learned friend says.
Otherwise, as far as I'm concerned, madam, my submission is very simple and single. The amendment which is under challenge in this writ petition matter is an amendment to the Assam Reservation Act of 1978. This amendment has been brought because of the judgment passed by Honorable Supreme Court in R.K. Sabarwal's case. Now, if that judgment remains, how can they challenge the act? The amendment in the act? That is the simple thing, my lord. They have to first show that
My
the
lord,
judgment is.
let him not submit on merit, my lord. Let us answer to your lordship's query, whether, my lord, it can be completed today.
Absolutely.
His argument is what, two-line argument,
Two-liner.
two-liner.
Yes.
I appear for the respondent. My argument is also one-liner. The government stand is that the this reservation came in terms of the Sabarwal. They have challenged the act on grounds of nepotism, favoritism, and violation of Article 14 and 16, possibly unheard of petition. Well, it's a misconceived petition. So my thing is that the reservation is constitutionally permissible, not violated. So if nepotism is the ground of challenge, then for 77 years, nepotism was going on in India. So my case is that it should be dismissed with cause. That is my.
They have already concluded their argument.
Yes. Then, my lord, let me, may I, my lord, submit?
Definitely, carry on. Yes.
Now, my lord, the big points I'll give, my lord, initially before explaining. Article 16(4)(a) was, my lord, brought by an amendment. And the provisions of the Assam SC and SC Act 2012, as amended in 2012, that, my lord, violates Article 16(4)(a).
Let's see
As
the act which is under challenge.
My lord, the act is,
Placed
my
on
lord,
record.
my lord, it is on record, but perhaps, my lord, the book will be more convenient. It is a part of the petition. But then your lordship may take the book and read, that will be convenient perhaps. I have given a list of books.
Yes, the book is, the act is here at page 34.
Yes, my lord.
You may read from the appeal, it's a petition itself.
It's someone young.
This emanates from directions given in R.K. Sabarwal.
Yes.
My lord, that is what this, my learned phrase submission is, but then, my
Then
lord, there is
you
no
have to,
affidavit.
you have
So,
to straight off satisfy the court that no, that is not a correct correct submission.
My lord, there is no affidavit from the state. My submission is that, my lord, Article 16(4)(a) and, my lord, some other provisions of the act, those were challenged. My lord, some amendments of the constitution were challenged in, my lord, M. Nagraz. The Honorable Supreme Court, while upholding that those amendments are in order, but gave some directions, riders, which become, my lord, in my humble submission, a part of the Constitution. Because, my lord, Article 16(4), as your lordship knows, is a, my lord, enabling provision. My lord, I'll just read the article once, my lord.
Definitely. Yes.
Article 16 is, my lord, equal opportunity in matters of public employment. Then, my lord, Article 16(4)(a) that was inserted by, my lord, 81st Amendment in 2000. Now, may I read, my lord, Article 16(4)? Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, I'm, my lord, stressing on this word, in the opinion of the state, is not adequately represented in the services under the state. Then 4(a), nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of posts in the services under the state in favor of scheduled castes and scheduled tribes, which, in the opinion of the state, are not adequately represented in the services of the state. Now, my lord, there is one requirement, but this enables the state to make laws for reservation and promotion. We are confined to my reservation and promotion only, my lord, not for appointments. And there is a requirement of the state forming an opinion. So, my lord, how that opinion has to be framed, that has been discussed in my lord M. Nagras.
Yes.
I'll read certain paragraphs of the my lord M. Nagras, and that has been, my lord, subsequently a little modified by Jarnil Singh judgment. And my lord, there is also a decision of this honorable court. In fact, my lord, there is a division bench decision also, which also I'd be, my lord, I'd like to bring to your lordship's notice subsequently. First, my lord, let us go to, my lord, what is the law laid down by the Honorable Supreme Court in Nagraj? The relevant paragraphs are, my lord, paragraph 108, 117, and 123. M. Nagraj.
Yes, please.
Has your lordship got the judgment, mind? Has your lordship got the judgment, mind?
Yes, yes. 107. Para 107 you are referring. Ms. Chaudhary,
Yes, my lord.
you refer to three paragraphs, 108
108, 117,
and 123.
123.
Yes.
I'm reading, my lord, 108 first. Application of the doctrine of guided power, Article 335, because, my lord, when the reservation in promotion comes, my lord, 335, that requirement has also to be followed, my lord. Applying the above test as to the provision of Article 335 inserted by the Constitution 82nd Amendment 2000, we find that the said provision has a nexus with Article 16.4a and Article 16.4b. Efficiency in administration is held to be a constitutional limitation on the discretion vested in the state to provide for reservation in public employment. Under the proviso to Article 335, it is stated that nothing in Article 335 shall prevent the state to relax the qualifying marks or standards of evaluation for reservation in promotion. This proviso is also confined only to the members of STs and STs. This proviso is also conferring discretionary power on the state to relax qualifying marks or standards of evaluation. Therefore, the question before us is whether the state could be empowered to relax qualifying marks or standards for reservation in the matters of promotion. In our view, even after insertion of this proviso, the limitations of overall efficiency in Article 335 is not obliterated. The reason is that efficiency is a variable factor. It is for the state concerned to decide in a given case whether the overall efficiency of the system is affected by such relaxation. If the relaxation is so excessive that it ceases to be qualifying marks, then certainly in a given case, as in past, the state is free not to relax such standards. In other cases, the state may evolve a mechanism under which efficiency, equity, and justice, all three variables, could be accommodated. Moreover, Article 335 is to be read with Article 46, which provides that the state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular the scheduled castes and scheduled tribes, and shall protect them from social injustice. Therefore, where the state finds compelling interest in backwardness and inadequacy, it may relax the qualifying marks for SCs and STs. These compelling interests, however, have to be identified by weighty and comparable data. Then your lordship may kindly come to page paragraph 117. The taste for judging weight of the power and the taste for adjudicating the exercise of power by the state concerned are two different tastes, which warrants two different judicial approaches. In the present case, as stated above, we are required to taste the width of the power under the impugned amendments. Therefore, we have to apply the width test. In applying the width test, we have to see whether the impugned amendments obliterate the constitutional limitation mentioned in Article 16(4), namely backwardness and inadequacy of representation. As stated above, these limitations are not obliterated by the impugned amendments. However, the question still remains whether the state concerned had identified and valued the circumstances justifying it to make reservation. The question has to be decided case-wise. There are numerous petitions pending in this court in which reservations made under the state enactments have been challenged as excessive. The extent of reservation has to be decided on the facts of each case. The judgment in Indra Sahni does not deal with the constitutional amendments. In our present judgment, we are upholding the validity of the constitutional amendments subject to the limitations. Therefore, in each case, the court has got to be satisfied that the state has exercised its opinion in making reservation in promotion for SCs and STs, and for which the state concerned will have to place before the court the requisite quantifiable data in each case and satisfy the court that such reservation became necessary on account of inadequacy of representation of SCs and STs in a particular class or classes of post without affecting general efficiency of service as mandated under Article 335 of the Constitution. Then your lordship may come to the, my lord, final directions. Your lordship may also like to read from paragraph 121 because these are the conclusions, my lord. May I read 121?
Yes.
The impugned constitutional amendments by which the Articles 16(4)(a) and 16(4)(b) have been inserted flow from Article 16(4). They do not alter the structure of Article 16(4). They retain the controlling factors or the compelling reasons, namely backwardness and inadequacy of representation, which enables the states to provide for reservation, keeping in mind the overall efficiency of the state administration under Article 335. These impugned amendments are confined only to SCs and STs. They do not obliterate any constitutional requirements, namely selling limit of 50%, quantitative limitation, the concept of creamy layer, qualitative exclusion, the sub-classification between OBCs on one hand and SCs and STs on the other hand, as held in Indra Sahni, the concept of post-based roster with inbuilt concept of replacement as held in R.K. Sabharwal. We reiterate that the selling limit of 50%, the concept of creamy layer and the compelling reasons, namely backwardness, inadequacy of representation and overall administrative efficiency, are all constitutional requirements without which the structure of equality of opportunity in Article 16 would collapse. However, in this case, as stated above, the main issue concerns the extent of reservation. In this regard, the state concerned will have to show in each case the existence of the compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency before making provision of reservation. So my case is that, my lord, before making this reservation provision, you have not done this exercise. As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SCs and STs in matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class and inadequacy of representation of that class in public employment, in addition to compliance with Article 335. It is made clear that even if state has compelling reasons, as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obliterate the creamy layer or extent of reservation indefinitely. Now, your lordship has seen, my lord, the dictum is that,
Compelling reasons,
my lord,
compelling reasons has to have to be there.
compelling reasons has to be there, and my lord, the state has to form an opinion.
Opinion
And
has to be
that
there.
forming of opinion is on the basis of quantifiable data.
Quantifiable data.
Now, this amendment of 2000, my lord, this has been a little modified by the General Singh's case. The requirement of the quantifiable data regarding backwardness is not required.
Is not required.
Is not required. So, my lord, it remains, my lord, only two data, my lord, regarding that, my lord, efficiency of administration and
Inadequacy of representation.
now, your lordship may like to see what the General Singh says, my lord.
Definitely.
In General Singh, my lord, paragraph 36. Final conclusions is paragraph 36, my lord. I'll read the conclusions only. That is, my lord, 2018 10 SCC 396. (35) and 36, my lord. 35 will also be relevant. May I read it, my lord?
Just.
The learned attorney general
Just hold
also.
on.
Oh, my first. I see. Get up. Yeah.
Yes.
Paragraph 35.
35.
The learned attorney general also requested us to lay down that the proportion of scheduled castes and scheduled tribes to the population of India should be taken to be the test for determining whether they are adequately represented in promotion post for the purpose of Article Section 4A. He complained that Nagraj ought to have stated this, but has said nothing on this aspect. According to us, Nagraj has wisely left the test for determining adequacy of representation in promotional posts to the states for the simple reason that as the post gets higher, it may be necessary, even if a proportionality test to the population as a whole is taken into account, to reduce the number of scheduled castes and scheduled tribes in promotional posts as one goes upwards. This is for the simple reason that efficiency of administration has to be looked at every time promotions are made. As has been pointed out by BP Jivan Reddy's judgment in Indra Sahni, there may be certain posts right at the top where reservation is impermissible altogether. For this reason, make it clear that Article Section 4A has been couched in a language which would have to be leave it to the states to determine the adequate representation depending upon promotional posts that is in question. For this purpose, the contrast of Article Section 4A and Section 4B with Article 330 of the Constitution is important. Then, my lord, Article 330 is, my lord, quoted. Then your lordship may come to paragraph 36. Thus, we conclude that judgment in Nagraj does not need to be referred to 7 judgments. However, the conclusion of Nagraj that the state has to collect quantifiable data showing backwardness of the scheduled caste and the scheduled tribes being contrary to the 9-judge bench of Indra Sahni is held to be invalid to this extent. So, my lord, that requirement has been done away with.
Has been done away with. So now the only issue which now survives is regarding the efficiency of administration.
My lord.
Efficiency of administration.
Yes. No, my lord, both efficiency of administration and adequacy of representation.
Adequacy of representation would be directly connected, linked with the quantifiable data then.
Yes, ma'am.
Why not? So if when quantifiable data concept has been struck down or watered down.
No, quantifiable data has been struck down to the extent of the requirement for determining the backwardness.
Backwardness.
Only backwardness. So backwardness goes away, but inadequacy of representation and efficiency of administration remains. The
So where is your ground? Let us read your ground on this aspect.
in the petition?
Ground of challenge in the writ petition.
Grounds, my lord, I have taken many, but the, my lord, relevant will be.
Yes.
Let us start from my lord. 14J at page 13.
Yes. G.
J.
14G.
J, my lord.
Yes.
J at page 14. my lord.
J is at 14. Yes.
That the position after the decision in M. Nagaraj's case is that reservation of posts and promotion is dependent on the inadequacy of representation of members of the scheduled caste and scheduled tribes and backwardness of classes and subject to the condition of ascertaining as to whether such reservation in such view of the matter was at all required. The said principle of law was also reiterated by the Supreme Court in UP Power Corporation. Such and such, the Supreme Court, while observing that Article 16(4)(a) is only an enabling provision for the state to make laws for providing reservation in matters of promotion, will however have to subject itself to a fresh exercise for ascertaining the need of reservation, and on satisfaction thereof can only proceed to make required provisions of law. The Honorable Court further played down the argument that once the principle.
Mr. Mazumdar, before Mr. Chaudhary concludes, what is your response on this required exercise that before framing these this provisions, this statistics inadequacy of representation of the particular caste? It's not that general the opportunities to be given.
The writ petition, the prayer is that the provisions of Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Service in Post Amendment Act 2012 is under challenge. This amendment has had to be brought in because for the first time, my lord, in the case of R.K. Sabharwal, the Honorable Supreme Court has said that see, the reservation will not be vacancy based, it will be post based. Only for the purpose of introducing the scheme of post based roster, certain amendments had to be brought in the Act of 1978. And that is under challenge in this case.
So the original act is of 1978.
My lord, this amendment brought in the 1978 Act by virtue of basically and wholly based on the R.K. Sabharwal judgment has got nothing to do with this collection of quantifiable data.
The quantifiable data, they themselves say that is no longer.
Quantifiable data is required for making
Backwardness.
Promotion.
Yes.
Reservation, we are not concerned with reservation promotion in this case, my lord.
Then
it is only about roster, my lord, post-based roster and not vacancy-based. Because, my lord, in R.K. Sabharwal judgment, the Honorable Supreme Court has said,
this amendment is only post-based roster.
my lord, because there is a reason, my lord. What has happened, my lord? Supposing, Lordship may kindly bear with me for a moment. Supposing the 10% of the post is reserved for a particular category of reserve category. Now, every time 5 vacancies arise and we make reservation of 10%, a time will come, their reservation will exceed 60%.
Yes.
That is why in the case of R.K. Sabharwal, all the Supreme Court has said, no, entire cadre strength will have to be taken into consideration to find out what is the total strength. And we'll calculate what is the 10% of that strength. If it comes to 6, then the roster will be prepared in such a way that for working out the entire roster, and after working out the entire roster, they get only 10 posts, not beyond that.
Not beyond.
That is the thing, my lord. All other arguments are, my lord, just irrelevant to the challenge made in the writ petition, my lord.
Okay.
These are brought only for the purpose of if my lordship permits me, to confuse the court, my lord, nothing else. Because this has no relevance, my lord. We are not here my lordship is not hearing a case where the reservation policy as such is under challenge. In fact, my lord, the same petitioner had challenged the reservation policy. Writ petition was dismissed. Writ appeal has been dismissed the other day. Now, if they are agreed by that, because their argument that quantifiable.
Where is the judgment?
Yes,
This is the judge.
this is the
That's-
judgment.
All points taken by my learned senior counsel have been answered.
It's-
And the data regarding inadequacy is the cadre. Efficiency, if they go on saying it is racism.
But that argument is
Supreme
not,
Court has said that you can't bring efficiency,
My lord,
but we compete on merit. We go ahead and we go higher.
if you're.
It is basically of the
আর এটা
highest
কপি আছে নাকি?
Okay, okay. Mr. Chaudhary, what do you say to this judgment? IV Gohain,
Yes.
Para 43 answers all the questions. And all questions of my learned senior counsel has been rejected. In terms of Supreme Court's order, very detailed order. In fact, page 7, 38 is the operative part. I mean, if I may read.
yes.
With regard to the contention of Sri M.K. Chaudhary, learned senior counsel for the petition, because they are also the same equality forum where we take note that as per paragraph 47 of the judgment dated 23/12/15, in equality forum, there is an express prohibition by the judicial pronouncement that till such quantifiable data on backwardness, inadequacy of representation and efficiency in administration is collected, no reservation in favor of the reserve can be further carried out. But paragraph 74 of the judgment in equality forum provides for collection of data in respect of backwardness of the reserve category as well as inadequacy of their representation, which again will have to be determined cadre-wise and service-wise in the respective department. And further, on such data being obtained, there would be a requirement of harmonizing with the efficiency in administration as provided under Article 335 of the Constitution of India. But the requirement of the provision in the judgment dated 23/12/2015 in Equality Forum would again have to be read in the context of the submission of D.K. Das, learned counsel, for the unreserved candidate, that in paragraph 36 of the journal, there is a presumption in favor of backwardness. Of the reserved
Backwardness,
candidate.
yes.
And in view of such presumption in law, there is no further requirement of any quantifiable data to substantiate the position. The said position being rendered by. Please. The said provision being rendered by a constitution and bench judgment of the Honorable Supreme Court, which read together with the provisions of the judgment in Equality Forum 1, it has been understood that there would be no further requirement under the law for any collection of quantifiable data to substantiate the backwardness of the.
And inefficiency in administration.
Further, efficiency is in paragraph, yes. Lordship,
Para 43.
43.
Yes.
As regards, this clinches the issue. As regards the three contention raised by Sri M.K. Chaudhary, learned counsel for the petitioners are answered as indicated above, meaning thereby that as per judgment of the Honorable Supreme Court rendered in paragraph 36 in the Journal Singh, there is no requirement of obtaining quantifiable data as regards backwardness, and as per judgment rendered by the Honorable Supreme Court in paragraph 116 and 126 of B.K. Pavitra 2, quantifiable data on efficiency in administration across the board in respect of reserve category cannot be obtained. And further, as the quantifiable data in respect of adequacy or inadequacy of the representation of the reserve candidate can also be done at the level of the DPC in respect of the cadre for which such promotion process has been initiated. We are of the view that the prohibition imposed in paragraph 47 in judgment dated 23/12/15 in Equality Forum would have to be understood in the manner indicated. In other words, as there would not be any requirement of obtaining quantifiable data on backwardness and inefficiency in administration, and obtaining the data regarding adequacy or inadequacy of the representation can be done at the level of the DPC, that is the Departmental Promotion Committee. The prohibition imposed by paragraph 47 of Equality Forum would no longer hold good, subject to the condition that the DPC, before embarking such on every promotion process, undertakes an exercise to determine the adequacy or inadequacy of representation of the reserve category in that particular given cadre where promotion is sought to be made. My lord, basically what has happened, the requirement is that quantifiable data on inadequacy will be cadre. And the cadre-wise data was not done where I have challenged it, and which is now Lordship has sent it before the single judge, because the Assam government did not want to follow the judgment of the single judge and the division bench. Now, insofar as the efficiency is concerned, D.K. Pavitra says it is
We'll continue at 2.
Yes.